All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning, everyone.
Good
We
morning.
have three cases on this morning's calendar. The first case is Dwayne Hilton versus United States, and we shall proceed to hear that case. Counsel?
Thank you, Your Honor. May it please the court, Deborah Soltis on behalf of appellant Dwayne Hilton. I'd like to reserve 3 minutes for rebuttal. Mr. Hilton stands before this court having been convicted of armed first-degree murder, AWICWA, and related weapons offenses in connection with the Briscoe shootings. Mr. Hilton's convictions are the result of a trial that was infected with a glaring and inexplicable Brady violation, as well as other several critical evidentiary errors that also implicated his constitutional rights. Specifically, Mr. Hilton seeks a reversal of his convictions on 4 grounds. First and foremost, that the government violated its Brady obligations by failing to provide him until 1 month after his trial was over with extensive investigative evidence showing striking similarities between the Briscoe shooting and the subsequent shooting of a Briscoe shooting survivor victim, Kevin Johnson. In addition, he seeks reversal based on the trial court's erroneous denial of his pretrial Winfield motion based on evidence of a viable third-party perpetrator. The trial court's denial of his motion to suppress identification testimony that was rooted in a grainy, indiscernible video, and the trial court's reversible error in allowing the government to introduce evidence of Robert Mallory, one of Mr. Hilton's purportedly close friends, murder 4 years before the Briscoe shootings as alleged motive.
Ms. Soltis, I'd like you to clarify for me the essence of your Brady argument. Does your claim of a Brady violation depend upon this information being admissible under a third-party perpetrator theory, or do you have a different Brady? Let's assume a third-party perpetrator issue will not fly. If you have a different Brady theory, I'm eager to hear it.
Yes, Your Honor. Thank you. And I do. Per several decisions of this court, including Andrews and Vaughn, as well as the Supreme Court's decision in Kyles, Brady materiality determinations do not turn on actual use at trial. Specifically, whether a trial attorney would have actually used suppressed Brady evidence or whether the defendant could demonstrate actual use is irrelevant once evidence is found to be favorable and suppressed. That comes from this court's decision in Andrews.
You can't mean that it's irrelevant because Brady includes a prejudice component. So in what way would things have been different in your client's favor had this been disclosed earlier?
Your Honor, if this court, for instance, turns to its decision in Vaughn, I think that gives a really good example of non-actual admissibility, but still impact at trial. In Vaughn, the government tried to argue that suppressed evidence of a report calling into question a testifying officer's credibility was not material under Brady because the defense couldn't show that it would have been admitted. This court unanimously rejected that argument, holding that the issue is not whether the evidence would have been admissible, but whether pretrial disclosure by the government of the suppressed materials and knowledge by the government that the defense knew all about those materials would have likely affected the way the case played out. And that's exactly what would have happened here. Like in Vaughn, the government could not have pursued its key elements of its identification theory without serious and substantial cross-examination by the defense into the adequacy of the investigation if the defense had known about these Johnson materials beforehand.
So if I understand it, you're saying that when the government argued dreadlocks, left-handed, yada, yada, who else could it be, that the government could not have done that in light of the new evidence?
Absolutely not, Your Honor. They certainly couldn't have done it effectively, because if Mr. Hilton's very able trial lawyer had had these Johnson materials, he could have pushed back hard with a very common tactic of questioning the adequacy of the police investigation. That wouldn't have required that he get into a Winfield third-party perpetrator. He could have asked them about the purported uniqueness of left-handedness and dreadlocks, whether or not any other suspects, particularly those who had been previously identified as E Street enforcers, like Mr. Devon Bell, the prime suspect of the Johnson shooting, according to the 500 some pages that the government just supplemented the record with, whether or not the police had considered Mr. Bell as a suspect or had considered any other left-handed dreadlocked E Street fueled animus shooters in connection with the Briscoe shootings. But instead, Mr. Hilton's trial counsel couldn't pursue that line of attack because he didn't have these materials. In addition, yes, Officer Sturgis and Sharp, both of whom identified Mr. Hilton from that grainy video, specifically relied on left-handedness and dreadlocks. And again, these questions could have undermined the traits with which they were relying on that really blurry, indiscernible video to identify Mr. Hilton as that masked second shooter in the Briscoe shootings.
For this argument, does it matter whether we look at the facts you just summarized from a Brady point of view or a new trial motion point of view?
Your Honor, the difference, the de novo review under Brady of the materiality determination could affect this court's, I guess, deep dive into the review of whether or not this information would have made a difference, would have placed Mr. Hilton's case in a whole new light. So that, we have principally focused. Yes.
I'm sorry. No, I was just going to say, Judge Fisher's question asked you to assume that the defense would not have been able to meet the requirements of Winfield with this evidence. Do you disagree with that? However, I know you assumed it for purposes of answering his question.
I do. Thank you, Your Honor. I do. I believe that the evidence here that was contained in the Johnson disclosures clearly met the standard of materiality under Brady, and that the trial court erred in its analysis of the evidence. Winfield is, as this court has said repeatedly, a mere relevant standard, no requirement that the disclosures have to prove or even raise a strong probability that another suspect like Mr. Bell actually committed the Briscoe shootings. The standard is just the effect the evidence would have had upon Mr. Hilton's culpability. All that Winfield requires is some evidence, circumstantial or direct, of this third party's actions or motives or opportunities between the proffered evidence and the crime at issue. And the standard is really only that a trial judge would have been, quote, safely within her discretion to allow Hilton to present this information through a Winfield third-party perpetrator defense. And I think there's no question that when viewed cumulatively, the videos and the document disclosures would have allowed Hilton to proffer the following, and this would have satisfied the materiality. One, that Mr. Johnson was the target in both shootings, the Briscoe shooting and the Johnson shooting. Two, that the shootings happened roughly at the exact same location, a mere 2 blocks apart. Three, that both shootings, according to MPD, were motivated by the bad blood between the warring factions of E Street and Trinidad. Four, that both shooters shot with their left hand. 5, that both shooters had dreadlocks. Now, I know that the Johnson video doesn't necessarily clarify whether or not the Johnson shooter had dreadlocks, but all we have to do is look at the MPD files to see that after viewing that video, who did Detective Wilson and Detective Giancarlos and Detective Sharp zero in on? Devon Bell. Here's Mr. Bell for you. Mr. Bell, who had a long
Can you hold the
criminal.
picture up a little higher?
Oh, absolutely. I'm sorry, Your Honor.
Thank you.
Okay. Mr. Bell, long dreadlocks, even longer violent criminal history. With a notation back in 2000 by an AUSA who was prosecuting one of his cases, that he was suspected to be the man you go to when you want to enforce a grudge by E Street. A suspected E Street enforcer. That's what these files say. And that they get it, that these same detectives, notably the same detectives who are investigating Mr. Hilton's trial and the Briscoe shootings, they go and get a search warrant for Mr. Bell's apartment. And they recover weapons. And that
How does Mr. Bell compare in appearance and age to the shooters involved in our case?
You know, Your Honor, it's hard to say. I mean, the shooters in our case are indiscernible. I've watched that video so many times, and I still can't really detect anything that even the cops, the officers say that they see when they look at it.
They do seem to be young. They do seem to be youngsters.
I don't know what the age determination would be based on. And I also don't know that Mr. Bell is older. Mr. Bell was born in 1976. But you know what? He clearly wasn't done with his E Street days, according to MPD, because when Kevin Johnson was shot, they zeroed in on him regardless of his age. And I think it's really hard to determine what the age is of the shooters in the Briscoe shooting video. What we do know is that they shot with their left hand. And we do know that there is evidence that the Johnson shooting was committed by left-handers, and that these files also contain evidence that Mr. Bell himself was stopped once and had a knife in his left pocket, indicating left-handedness. And that in another case, Mr. Bell was described by a witness as using both hands to attack somebody, so arguably ambidextrous. So there's evidence not only that the Johnson shooting shows left-handed shooters, but that Mr. Bell himself may have been left-handed, or at least pretty competent with his left hand. And when you put all of those disclosures together, and that proffer that was made and was in front of the trial court, that was enough under Winfield. I know the government likes to argue that there was no practical opportunity. First of all, it's not a requirement under this court's decision in Battle, where there was no practical opportunity for the third-party perpetrator. And secondly, there was a practical opportunity for Mr. Bell. He was living in Beltsville. I Googled it, it's 20 minutes away from the scene of the Briscoe shooting. He wasn't incarcerated. And he clearly had the same motive that led the police to zero in on him in the Johnson shooting. And this wasn't new. It wasn't like Mr. Bell was somehow turned to as an E Street enforcer, after Mr. Hilton went to jail. No, Mr. Bell was identified and in this role, what seems to be for, 15 years prior to these shootings, 10 years prior to the Briscoe shooting and 15 prior to the Johnson shooting. So yes, Your Honor, I believe that while it's not necessary that the Brady disclosures would have satisfied Winfield, that they in fact would have satisfied Winfield. I'd like to point out that, ultimately, Brady and its materiality analysis is not a sufficiency of the evidence test. The government tries to compare the suppressed Johnson disclosures to what it likes to call the compelling evidence of Hilton's guilt. But the evidence wasn't compelling, and it's the wrong standard. All that Mr. Hilton needs to show is that the potential impact that these undisclosed materials would have had on the fairness of his proceeding. And in this circumstantial case, where the key issue was whether Hilton could raise a reasonable doubt about whether he uniquely matched the motive, left-handedness, hairstyle of the masked suspect in the Briscoe shooting video.
Well, wait, excuse me, Ms. Soltis.
Yes.
I don't understand what you just said. Nothing in the evidence about Mr. Johnson undermines the fact that Mr. Hilton is left-handed, that Mr. Hilton's motive was shown, that Mr. Hilton had dreadlocks, and it doesn't say anything at all about the fact that 3 people who witnessed the video identified Mr. Hilton. So I'm having a little trouble seeing how merely showing that another left-handed person with dreadlocks committed another shooting in connection with this neighborhood warfare that was portrayed at trial really amounts to evidence that could have affected the outcome of this case. The jury didn't rely centrally on the fact that, I mean, it's hard for me to believe, let's put it this way, that the jury at this trial thought, oh, left-handed and dreadlocks, those are such unique characteristics that we've got an identification here and we have our man. Those were simply a couple of corroborating features that corroborated the identification of Mr. Hilton by 3 people who watched the video. And nothing in the, if I understand correctly, nothing in the evidence about the Johnson shooting undermines those 3 identifications. Do I have that right?
Well, Your Honor, I would respectfully disagree that, first of all, that they were corroborating features. The government sought and over objection received an instruction from the court that only 10 to 15% of the population is left-handed. Clearly, the government believes—
So in the District of Columbia, that's 50,000 to 75,000 people, whatever. It's a lot of people.
But the fact is, Your Honor, that they believe that this was a significant distinctive feature. And why did they need a significant distinctive feature? Because the video was not very good. And the description of this pigeon-toed, bow-legged walk is indiscernible in the video. And the government knew the video, which trial counsel, I think, rather effectively characterized as a Rorschach during his closing argument, was not going to carry the day. And so it needed to pile on other factors, and those other factors were key. And the more you could add on, the more likely you narrowed the pool. And then you have the ID of Mr. Hilton by Officer Scharf and Sturgis, and the sort of the questionable, I guess, identification by Prince Thorne. And you put all that together, and that's the government's case. But when you start peeling away each of these other factors, that ID gets weaker and more vulnerable to question. And in addition, Your Honor, I disagree. If this evidence had come in as a Winfield, as a third-party perpetrator, this murder that had so many similar earmarks to the Briscoe shooting, there is certainly a reasonable probability that the jury would have said, Johnson's killed, Hilton's in jail. Johnson's killed very similarly, all these other things, left-handed dreadlocks, same motive, same location, East Street enforcer. Why couldn't have this? I have a serious question as to whether or not this guy who killed Johnson also shot at Briscoe and the others, and shot at Kevin Johnson twice, once in 2011, once in 2015. That's compelling, Your Honor. This,
What about the so-called getaway car evidence? What do you say about that? Was that strong?
Your Honor, it's not strong. It was circumstantial evidence that the government presented. Ezra Queen, who supposedly under the government's theory drove the getaway car, wasn't charged, wasn't in the case. And instead, it's really the presence of the car connected with the jailhouse calls that the government tries to connect another series of dots around Mr. Hilton, connecting him to the shootings. But when you look at the fact that there's no case against Ezra Queen, the evidence clearly wasn't strong enough, according to the government, to bring him in. And the jailhouse calls are ambiguous at worst, or at best, I guess, for the government. They display some knowledge of a shooting in a car. They certainly do not contain any evidence of admissions of guilt or even coded admissions of guilt. And Ezra Queen in the other calls repeatedly denies any involvement to his family, to his grandmother, I believe and possibly to his girlfriend. And so the calls, again, yes, there is something there, there's circumstantial evidence, but it's far from strong. What the government would have been left with was a blurry video. I mean, assuming that all the other heirs, were denied here and just the Brady is focused on, the government would have been left with a blurry video. Two police officers who claim they never speak to each other and yet describe an indiscernible walk on a video that shows nothing but nondescript ambulation as pigeon-toed, bow-legged, almost word for word. The car and the jailhouse calls. Oh, Your Honor, I can't hear you.
My apologies. Let me interject. We're going to give you a few minutes in rebuttal, but it's time for us to hear from the government, and then we'll get back to you.
Thank you, Your Honor.
Thank you. Mr. Smith?
Thank you, Your Honor. May it please the court, Peter Smith on behalf of the United States. The court did not abuse its discretion in denying appellant's post-trial Brady motion. The evidence that appellant, or the proffer that appellant made, was simply too speculative for defense counsel to have effectively used at trial. And in addition, there was no avenue of investigation that was foreclosed to trial counsel. Before trial, defense counsel knew that Kevin Johnson had been murdered. He knew the location of the murder. He knew that the murder was connected with the ongoing feud. That's in the July 26th transcript at pages 90 to 95. So the new information that appellant is arguing in his briefing this morning is that there would have been a viable Winfield suspect who I'll call S1. And as the court indicated earlier, there are significant differences between the person seen being appellant, the person seen shooting at Miko Briscoe and his companions in front of the Circle 7 in 2011, and the person almost 4 years later, 3.5 years later, shooting at Kevin Johnson. There's no indication that S1 was part of the neighborhood feud. There's no, S1 does not look like appellant. He's 15 years older. He is 5'7". At the time, he was 5'7" and 220 pounds. Appellant, on the other hand, was 6'1" and 180 pounds. And most importantly, the police officers who identified appellant in the video, the Northeast Market video, as the shooter of Miko Briscoe, said definitively that they knew S1 and they knew that the shooter of Miko Briscoe was not S1. That's in the appellant's sealed Appendix K at page 38. In addition, S1 would not have been a viable suspect because he had no link to the car. And I disagree with appellant's counsel that the car was not an important piece of evidence. The car was distinctive. It had distinctive damage on it. The government's evidence and testimony at trial was that it was Ms. Queen's car, that it was Ezra Queen's car that was the getaway vehicle. And appellant had a long-standing friendship with Ezra Queen. Appellant had lived around the time of the murder with the Queens in their house. There was evidence that Ezra Queen had a beef with people from Trinidad and that the shooting was part of that ongoing beef. So that was all important evidence. And of course, there was evidence that appellant had knowledge of the murder and also had told someone after his arrest that to don't say anything to the police about the murder. So there was other evidence corroborating the fact that appellant was the person who was on the video. And I'd like to make a couple of points about the video. Appellant's counsel argues that the video was grainy and it was not strong evidence. But of course, the video was played many, many times for the jury during the trial. It was stopped, it was narrated by one of the police detectives. The jury had an opportunity to see that video and to think about it. And in addition, as to the distinctive run or the distinctive look of appellant on the video, by way of analogy, evidence is admissible and properly before the jury if, for example, someone recognizes someone's voice. But the way that someone recognizes someone's voice is often hard for the witness to articulate. And so the fact that the police described appellant as being pigeon-toed or having a bow-legged gait doesn't necessarily mean that there's anything wrong with the identification. In fact, the police were very strong in their identification. They said they were positive that it was appellant. And appellant's argument ignores Princeton Thorne's testimony. Princeton Thorne knew appellant well from the neighborhood. Princeton Thorne believed when he came to the U.S. Attorney's Office that appellant was not the shooter. And when he saw the video, he broke down crying and said that it was appellant who was in the video. And that was a strong identification, and that was admitted into evidence at trial. So the bottom line is that there simply was not any reasonable probability of a different result had defense counsel had the information that was disclosed post-trial about Kevin Johnson's murder. And principally, that information is the video that shows two people running down an alley. The video is from a long way away and shooting at unidentified targets in the distance and then running away. As I mentioned before, defense counsel knew many of the other aspects of Kevin Johnson's shooting, and he knew that Kevin Johnson was one of the victims of the charged shooting in this case. And he knew the location, and he knew of Kevin Johnson's murder, and he knew it was connected to the feud. The new information was principally that video that shows the shooters running down the alley and shooting with their left hand. And that wouldn't have given rise to anything different, any of different result in this case. Appellant's theory was weak. Any sort of theory, Winfield theory predicated on S1 would have been a weak theory. And as I discussed a little bit earlier, there was strong evidence of appellant's guilt. Principally, it was the identifications, which were positive and strong. It was also appellant's connection with the car and appellant's own consciousness of guilt and evidence that appellant knew about the facts of the crime because he discussed with Ezra Queen in the jail calls the fact of the getaway car. He mentioned the getaway car and its importance to the police investigation. All of those indicated that appellant was properly convicted and that S1 would not have been a strong Winfield suspect.
You focus on X1 and then sort of use that as a target to say, well, it couldn't have been X1. Let's agree for now that it wasn't X1. You still have two left-handed guys in the video shooting Johnson. We don't know who they are, presumably, but there's a lot of similarity to the shooting of Briscoe. So leave X1 out of it. And what do we have there?
Well, Your Honor, I guess you have two responses. First of all, you don't have enough for any sort of Winfield defense because you haven't identified who those people are, whether they would have a motive to shoot at Kevin Johnson. I disagree with appellant's counsel that Kevin Johnson was, I'm sorry, Judge Fisher. I'm sorry, I can't hear Judge Fisher.
Judge Fisher, you're muted.
Technical glitches.
Sorry.
They obviously had a motive to shoot Kevin Johnson because we
Well-
see them doing it. Is it the motive about Briscoe that you're referring to?
Well, I guess I'm making 2 points. One, there's no connection between the two different shootings themselves. And I would disagree that they were motivated to shoot at Kevin Johnson in particular. They shot at a group of people who was in the mouth of an alley across from the alley where that the shooters ran down. The shooters ran down the 1269 alley, shot, and then ran back. And they were shooting at people who were located in the 1260 alley. And we don't know that Kevin Johnson was the target of the shooting. And we don't know that the shooting in 2015 and that he was killed, but they shooters were shooting at a group of people. And it would be sort of implausible to think that if Kevin Johnson had been targeted, that the shooter would have some beef with Kevin Johnson and would wait 3.5 years to, enact his revenge if the two shooters were the same. There was also no link. I mean, I guess in addition, there was no indication that the people, the left-handed shooters who ran down the alley were the same shooters or the same shooters at the Circle 7 where Miko Briscoe was shot in the charged homicide. The police officers testified that they knew S1, it wasn't S1. And there wasn't anything that appellant's counsel developed in between the disclosures and the filing of his post-trial motion that put any meat on these bones. Defense counsel had, as I mentioned, before trial a lot of information about Kevin Johnson's murder. And then the government started making disclosures in October 2016. Defense counsel filed the post-trial Brady motion in March 2017. That's 6 or 7 months later. And during that time period, having these disclosures, defense counsel still didn't really put any meat on the bones. So there wasn't any avenue of investigation that was foreclosed. There wasn't any argument that would have assisted defense counsel at trial that would have changed the outcome. That is to say that under Strickler for Brady purposes, there's no reasonable probability of a different result in this case.
Okay, does anybody on the panel have any questions for Mr. Smith? Seems not.
If there are no further questions, we urge the court to affirm the judgment of the Superior Court. Thank you very much.
Thank you. Ms. Soltis, I'll give you 2 minutes in rebuttal.
Thank you, Your Honor. First and foremost, to say that trial counsel for Hilton knew everything except the video prior to trial is a real misstatement. Trial counsel didn't know that the shooters were left-handed. Trial counsel didn't know that MPD had focused in on a prime suspect who had dreadlocks, which makes you think that MPD believed the shooters had dreadlocks. They didn't know any of the information contained in these 575 pages about Devon Bell, about potential other suspects, and about the retaliatory cycle here that the government.
One question, Ms. Soltis. I take it it is not established that Devon Bell was one of the shooters. Is it? Or has he been charged and convicted? Or
As far as,
what is the status of that?
well, Your Honor, as far as I know from the government, they've represented that there have been no arrests made in the Kevin Johnson homicide.
So all we have is the fact that there was someone who was, you could say, suspected, but that's as far as it went.
Well, it went farther. They got a search warrant, Your Honor, and they developed a lot of evidence connecting Mr. Bell to the Johnson. I don't know why they didn't go forward with prosecution. This will all be really interesting information to explore if, Mr. Hilton had had this information prior. Mr. Hilton's counsel could have asked the police officers directly. And I take Judge Fisher's comment to say, even setting Devon Bell aside, could have asked directly, Officer Sturgis, Officer Scharf, Officer Wilson, did you consider the left-handed?
I take your point, but I asked the question because at this stage, the burden is on you as appellant's counsel to establish the materiality of the information. And if that requires, we are where we are as a result. So any gaps don't really help you.
Your Honor, the fact that the government may have determined they couldn't prove beyond a reasonable doubt Mr. Bell's culpability in this shooting doesn't mean by a long shot that Mr. Hilton hasn't satisfied Winfield's reasonable probability standard of some impact by this evidence, let alone does it even touch the idea that having this information armed, enabled defense counsel's hands would have allowed a really effective adequacy of the investigation line of questioning to be made at trial, separate and apart of whether or not there was enough evidence to convict anyone of the Johnson shooting.
You were about to say that defense counsel could have asked Officer Sturgis, did you? And then you got cut off. What were you going to say?
Yes, thank you, Your Honor. Did you consider the left-handed shooters of Kevin Johnson as suspects in the Briscoe homicide? Yes, that could have been asked, and we don't know what the response would have been there. But having, that information would have allowed that really effective line of questioning. In addition, Your Honor, in rebuttal here, they could have, the government argues that that the Winfield was weak, which we have demonstrated. I don't believe it is, and I don't believe that Winfield's relevance standard was adequately analyzed by the trial court. The trial court leaped to admissibility. In fact, that's the only analysis of the Johnson disclosures under the trial court's opinion. Admissibility under Winfield with no consideration of any of this other potential use by defense counsel. And in addition, the government talks about the motive here, but this motive was long-standing. It was developed in these 575 pages as a retaliatory cycle that goes on for years, and that the government believed that Johnson's homicide was in retaliation for Heineken McNeil's horrific burning death, and that then Daryl Graves is killed in response for Johnson. And here's something really key about connecting Devon Bell to Johnson's homicide. When you read these materials, Daryl Graves' girlfriend says that she believes that Devon Bell was actually the target when Daryl Graves got shot. Why? Because of retaliation over Kevin Johnson's homicide. It just ties Bell in more and more. And finally, the idea that Mr. Bell may may appear, maybe older or too old to be the runner. I disagree. When you look at the video from the Johnson homicide, which the MPD had, and that they zeroed in on Mr. Bell, his age clearly wasn't a factor, because when you look at those guys running down that alley, they don't look, there's no discernible difference in their age from the age of the Briscoe shooters. So
Okay, I think we have your argument.
thank you, Your Honor. For these reasons, we would ask that Mr. Hilton's convictions be reversed, that he be entitled to a new trial.
Thank you. Counsel, thank you both. The case is now submitted, and we will proceed on to the next case. The two of you may log out. We will call the second case on the calendar this morning. Davon Payton versus United States. Counsel, you may proceed.
May it please the court. Stephanie Schneider on behalf of appellant Davon Payton. I'd like to begin with the Clark argument and then move to the Laney issue. I'd like to reserve 2 minutes for rebuttal. It was undisputed that a heavily intoxicated Harrison banged on Mr. Payton's window at 2 a.m. and threw the first punch when Mr. Payton came to the door. Mr. Payton had a compelling defense that he was lawfully acting in self-defense to push an attacking Harrison off of him when his gun accidentally discharged a single bullet, killing Harrison. This was a complete defense to all charges of homicide, including involuntary manslaughter. The judge erred in communicating to the jury that Mr. Payton's defense applied only to the greater offenses of second-degree murder and voluntary manslaughter. This ruling was contrary to Valentine and to Clark, which expressly adopted Valentine's reasoning and the centuries of common law it relied on. Valentine held that accident during the course of lawful self-defense excused involuntary manslaughter on a very similar fact pattern to the one we have here. In that
Ms.
case,
Snyder, would you clarify something for me? If I understand the record, at one point, the judge proposed to actually tell the jury that accident is not a defense to involuntary manslaughter. But if I understand, the judge backed off of that and never made that statement. It's simply that the judge did not refer to accident as a defense during the instructions on involuntary manslaughter. Do I have that right?
That's correct. I think what happened was the parties had initially, well, that's correct. I think that the judge on the day that she gave the instructions, she proposed, I want to make it even more express that it doesn't apply. There was some back and forth, and then they ended up staying with the instructions as they had been proposed the day before, which were, designed to communicate to the jury that accident didn't apply. I think that the government has conceded that they were expressly designed in language and structure to communicate that the accident during the course of self-defense did not apply to involuntary manslaughter. And in fact, that is precisely why the government said it was asking for this lesser included of involuntary manslaughter at the last minute, because they thought it was a way to get around Mr. Payton's defense. And, I'll walk you through.
Is it your view that accident would be a complete defense to involuntary manslaughter, even if Mr. Payton was, I'll use the shorthand, grossly negligent, which is, and by that I mean that he should have realized that his actions posed a grave danger, bodily harm, and was grossly at fault for failing to control his actions to avoid that harm. Sometimes we call that criminal negligence, but my point being, the term accident covers a lot of territory, and I don't understand it to be true, and I wonder if you do, that saying the word, "This was an accident," while I had the right to exercise self-defense because I was under attack, is enough to exculpate him or excuse the homicide that occurred.
Well, so just to be, to be clear, we're not saying accident in isolation. I mean, the key part of the defense turns on him being involved in a reasonable act of self-defense at the time the accident occurred. And, that's what the holding was in Valentine. That's what centuries of common law talk about.
No, I understand that. The premise is that he had a right to defend himself, and what he was intending to do was proper, but that without intending it, that's what accident essentially means. Without intending it, he fired his gun at the victim, and the question is that I'm asking you is do you think that's enough by itself to excuse him, or does there come a point where if he was so grossly negligent in his behavior that and the gross negligence caused the homicide, that he would still be liable for involuntary manslaughter?
So I think it's important to be sort of clear on the standard here. If the
Because I
act was a
read
lawful, so it wouldn't be grossly negligent, right? If it was a lawful act of self-defense, right? Because a lawful act of self-defense, it assumes that it was reasonable under the circumstances as they appeared to the defendant at the time of the offense. So if he was engaged in a lawful act of self-defense, sort of that defeats the charge.
Well, then the fact, if that's true, but that's not the issue before us. I mean, if that were true, you wouldn't have a case here because the absence of the accident instruction would be irrelevant. The point is that he may have a right to self-defense, but what the accident theory has the potential for getting him is over the hump of, well, you had the right to self-defense, but you overreacted, or you were so careless. You had the right to defend yourself from a punch. That didn't mean you could pick up a brick in defending yourself and bash it over the man's head. And and then say, well, it was an accident. I didn't mean to bash it over the man's head. The jury might still convict if it found that this response was grossly negligent. That's the way I understand involuntary manslaughter, and I'm wondering if you do not.
So I don't understand. I know the government has argued that there's a different standard of self-defense when you're looking at involuntary manslaughter. I don't read.
It's not the standard of self-defense. His conduct did not amount to valid self-defense because the shooting was, if he had intended the shooting, it would have been an excessive response, and so he would have been convicted. But the shooting, we're positing, the jury could find, was unintentional. Okay.
Mm-hmm.
What I'm asking you is it your argument that the mere fact that the jury could have found that it was unintentional, which was the predicate for giving the involuntary manslaughter instruction, enough to say unintentional is just another word for accident here? Okay. My problem is, and where I find myself confused by the law here and the issue, is I don't think the fact that it was unintentional and occurred in the course of a right to defend himself is enough to provide a complete defense to involuntary manslaughter, because involuntary manslaughter still has that requirement of, if you're grossly negligent, then you're still guilty. And that's what I'm trying to clarify with you. Do you think the fact that it was an accident, accident covers a lot of territory. It could be, there might not be any negligence at all. There might be some negligence, but just ordinary negligence, or it might be gross negligence. And I'm asking you whether you think any of those things matter. If it's an accident.
So I don't think it's that the accident itself is enough, but I think it was a jury question here, whether it was a lawful act of self-defense to push Mr. Harrison while holding a gun. And that's the question. They have to decide not to shoot him. We all agree, I think, that shooting would be excessive force, but the jury has to decide, given the circumstances of this case, right? The circumstances here where somebody has been banging on his window at 2 a.m. in the middle of the night where his daughter is sleeping.
I don't think
He
you're
comes to
answering
the
my
door.
question. I don't think you
Well-
grasped. I don't think you grasped my question. I'm assuming the jury could decide that Mr. Jackson was the aggressor, and that Mr. Payton was engaged in a lawful act of self-defense in the sense, not that he could shoot him, but in the sense that he could defend himself and use with force to do so. And I'm assuming the jury could also decide that he, and this is the predicate for involuntary manslaughter, that he didn't intend, that Mr. Payton did not intend, in the course of acting in self-defense, to shoot Mr. Jackson. You seem to think that if the jury decided all those things, that would be the end of the inquiry, or at least that's
Yes.
one way I hear in your argument. You seem to think that if it's an accident, that under Clark and under Valentine, that's it. It's a defense under those circumstances where the jury makes those other findings that I just summarized. And I'm questioning that because my reading of Valentine and my reading of Comber and my understanding of involuntary manslaughter is that if Mr. Payton's firing of the gun is properly characterized as what I'll use in shorthand, grossly negligent, then the fact that it was an accident in the course of lawful self-defense does not excuse the shooting, and he's still guilty of involuntary manslaughter. And I'm asking you whether I have that right or you disagree with that.
We disagree with that. Our position is that as long as the jury finds that it was a lawful act of self-defense to, push Mr. Harrison off him, even though he had that gun in his hand, pushed him off him, he's being punched, he's being held by the hair, and he responds by pushing him. If they find that that act was a lawful act of self-defense, then yes, the accident that ensues during the course of that excuses involuntary manslaughter. And I want to point
What do you mean
how
by, what does the jury have to find that pushing off of him with the gun in his hand a, quote, lawful act of self-defense?
that it was reasonable under the circumstances as they appeared to Mr. Payton at the time of the attack. I mean, it's just.
Well,
it's
then you're just building in the lack of gross negligence into your definition of lawful self-defense, and you're avoiding, and by doing that, you're avoiding answering the
But the
question
different, I
that
think,
is bothering me.
I think the difference is that when you're dealing with, it's not pure self-defense. I mean, everyone agrees it's not pure self-defense, because self-defense presumes, it was intention, that the person was in fear for their life. They were reasonably in fear for their life. And then they intended the response. I mean, that would be pure self-defense. This is a hybrid, an amalgamated defense. And I think it's worth looking at how equivalent this case is to
Suppose the jury in this case found all the facts that you would like them to find that we've talked about, but the additional fact that this was really grossly negligent on the part of Mr. Payton to have a cocked and loaded gun and to be holding it in such a way that he was pointing it at Mr. Schneider and knew he had that gun, and he didn't put it down. He didn't try to point it in a different direction. We think that while this was an accident and he was defending himself as he could, he was grossly negligent and the shooting should not be excused. Suppose the jury had thought that, which they could have thought even with the instruction, I think, that you asked for, although I'm not sure, because what counsel asked for was itself problematic. But you see the question, does my reformulation help you in answering my question? Could the jury find it
think-
was grossly negligent?
I think they would still be looking at whether or not it was a lawful act of self-defense, and they may find it was not in that context. But what we have, that's right.
Well,
I
that
think
hasn't, so you, all right, so you agree
I-
that an instruction to the jury that they've got, that they've got to convict him if they find this gross negligence that I've talked about would have been a correct
I
instruction.
think that's the wrong. No, I think that's the wrong formulation. I think it's just the formulation is that they're looking at whether or not the act was a lawful act of self-defense, and they take into consideration where the gun is, why the gun is there. I mean, all of that is part of their determination as to whether
I
the
think
act
you're
is a lawful act.
You're blurring the difference between lawful self-defense and accident, frankly.
But I think that, well, if we take a step back, I mean, you could potentially have the same problem with second degree, which is a conscious disregard. I mean, I think one could, under this line, one could say the same thing about, couldn't we find it was a conscious disregard? But I think that the question is, if it was a lawful act of self-defense to do it and the accident ensues, it's a complete defense.
With second degree murder, he's guilty of second degree murder if he consciously, as you say, disregards. The difference here is that with involuntary manslaughter, the disregard is not conscious.
I mean, I think under the questions you're asking, Valentine would have come out entirely different, right? I mean, these facts are identical to Valentine. And Valentine, the defendant, was holding a knife in her hand when she was, attacked and threatened and hit on the head. She responds instinctually and in self-defense, striking back with punched fists, forgetting the knife is in her hand, stabs the decedent 6 times, once fatally in the heart, right? And what the court said is that this is a quote from them: "The unfortunate result does not constitute the commission of any crime, but is homicide by misadventure and lawful self-defense from an unwarranted attack." And in that case, the facts were all agreed upon, and this case was reversed. Her involuntary manslaughter conviction was reversed.
I'll point out to you that on the following page of Valentine, the court was at some pains to say, and I'll quote you part of the paragraph: "The character of the attack made upon her and the manner and means of self-defense exercised are to be considered to determine whether or not the accused was guilty of such negligence or recklessness under the circumstances obtained to constitute her action an improper performance of a lawful act and so render her criminally responsible." In other words, if for example, in Valentine, if it had been perceived that she knew she had a knife in her hand and that she was basically extremely careless in responding to these punches by sticking the knife into the victim's heart, as she did, the jury could have found her grossly negligent. Or whatever the Virginia equivalent is to our standard for involuntary manslaughter. And in that case, a conviction for involuntary manslaughter would have been sustained. The reason Valentine gets off entirely is because everybody believed that she was not grossly negligent, that this attack came as a surprise to her and that she instinctively responded, that she happened to have a knife in her hand. Well, the facts of this case are a little bit different for that, for one thing. But it's still not, the reason I'm raising this point is because I'm wondering whether the instruction that the judge actually did give, which basically required the jury to find that, if I understand correctly, required the jury to find that Mr. Payton was acting in self-defense, lawful self-defense, and that he was not grossly negligent, basically was sufficient to give the defense the protection that it wanted. And maybe you could address that point.
No, I mean, it was not sufficient, right? Clark holds that a defendant is entitled to an instruction on his theory of the case to exculpate.
Well, you got that. You got
to
that?
explicate his accident in the context of the right to self-defense, but he didn't with respect to involuntary manslaughter, right? So he had this defense theory instruction, but the way that the other instructions came in, it made it seem to the jury as though accident plays no role whatsoever, in considering a charge of involuntary manslaughter. And that was done in
This gets us back to what you mean by accident. The jury is told that in order to convict for this unintentional act, you've got to find, at the very least, gross negligence. That sounds like an equivalency to a proper accident instruction, because you wouldn't say, I don't think, that even if the accident was the result of gross negligence, if you want to read, I'm using shorthand, if you want to read the statute, the conduct that caused the death was a gross deviation from a reasonable standard of care and created an extreme risk of death or serious bodily injury. I've been saying gross negligence as a shorthand for that. I don't see how the jury could acquit him of involuntary manslaughter if it said, well, this was an accident. Now, he was grossly negligent, but we're acquitting him because of involuntary manslaughter because it was an accident. The whole premise of gross negligence is it's an accident.
I mean, our position, right? Our position
That's
is
what I'd like you to address.
Our position, right? Our position is that if the jury concluded that Mr. Payton was lawfully acting in self-defense, and by that I mean to, push Mr. Harrison off him, even though he had that gun in his hand, if they found that was lawful self-defense and that it was an accidental discharge, they were required to acquit him. And that was not communicated to the jury because of the way these instructions came in. The jury was told when they got the elements on second-degree murder and voluntary manslaughter, they were told that the government had to prove beyond a reasonable doubt that Mr. Payton did not act in self-defense or by accident. When they got to voluntary manslaughter.
That's because accident there operates to undermine the intentionality. That's slightly the wrong way to put it. The mens rea for manslaughter and for voluntary manslaughter. And
well, it doesn't actually for second degree action. Second degree can actually be an accidental killing, but before the government at the last.
Not quite. The difference is you have conscious disregard of a known risk. So accident. I mean, you're right technically, but
prior to the government asking at the last minute for the involuntary manslaughter instruction, the way that the instructions were going to be given to the jury was they were going to hear, right, that second degree involuntary manslaughter, they were going to be told in the elements that the government had to prove beyond a reasonable doubt that Mr. Payton did not act in self-defense or by accident. And then they were going to get the defense theory instruction and they would
that begs the question. So let me ask you a question. Can I ask you a question?
Yes.
Is that instruction exactly accurate? Because by your own acknowledgement, Mr. Payton acted in conscious disregard of a known risk of serious bodily injury and so forth. He could still say, well, it was an accident. I consciously disregarded that risk, but I didn't intend it to occur, and it was an accident. I think one would say accident is not a complete defense to that. Now, that depends on what you mean by an accident, but it sounds to me almost as if your argument is that the instruction that the judge gave on accident for second-degree murder is slightly off for that reason.
So if we could, I think if we could back up. Initially, defense counsel had asked for a specific standalone instruction on accident that would have explained that when you use the term accident, was accident during the course of lawful self-defense. As the parties, during the course of 4 days of discussions, the parties agreed on a series of instructions by which, when they were talking about second-degree murder and voluntary manslaughter, in the elements, they would be told the government had to prove beyond a reasonable doubt that Mr. Payton did not act in self-defense or by accident, and then there would be the defense theory instruction that would pull the two together and explain how they interacted. That wasn't where defense counsel started. He had requested a more specific instruction, but ultimately that was what the parties and the judge agreed on with respect to second degree involuntary. What changed was at the very last minute, the government said, we are going to ask for an involuntary manslaughter lesser included. They had previously represented that they were only asking for voluntary. At the last minute, they said, we also want involuntary. And so then there was that reopened up discussions about the instructions. And what the government said is they took the position that Mr. Payton's defense did not apply to involuntary manslaughter, which we objected to. And so then the judge agreed with them and structured and wrote the instructions in such a way to communicate that. So when you get to involuntary manslaughter, the jury accident is not referenced at all. When the judge talks about the accident instruction, gives a standalone instruction, she says that the government, that in order to prove defendant guilty of murder in the second degree while armed or voluntary manslaughter while armed, the prosecution has a burden of proving he did not shoot Mr. Harrison by accident. Says nothing about involuntary. Then when it gets to self-defense, it says that for self-defense is a defense to all three offenses. And when it talks about involuntary manslaughter by itself, and it does the elements, right, it doesn't reference accident at all. So now what the jury sees when they're looking at those, they hear the instructions that are looking at them, they see that whenever we're talking about second degree and we're talking about voluntary manslaughter, we're talking about, we need to consider accident, we need to consider self-defense, but when we get to involuntary manslaughter.
What do you think the jury found in convicting Mr. Payton of involuntary manslaughter?
I think that the jury, I think in this case, probably the jury looked at the defense theory. Mr. Payton had a very compelling defense. I think the defense of, accident during the course of lawful self-defense, was supported by the record, right? I mean, it was undisputed. Mr. Harrison threw the first punch. The judge found he was the aggressor. It was a single bullet. Mr. Payton, apologized profusely afterwards, said, why did you come at me?
Well, no, I meant when I said, I didn't make my question clear. What elements did you think the jury found to find Mr. Payton guilty of involuntary manslaughter?
Well,
they found him guilty of involuntary manslaughter because he didn't act in self-defense.
Presumably they found all the elements, but I think.
What do you think all the elements are? It acquitted him of the intentional offenses.
Right.
And convicted him of involuntary manslaughter. What do you think the jury found in convicting him of involuntary manslaughter? Not what, facts, but what elements?
I mean, I think they would have found all the, obviously they found, right, so that he caused, they would have found that he caused the death. They would have found he was grossly negligent in doing so, that there was an extreme risk of death or serious bodily injury. They would have found all of those, and that he wasn't acting in self-defense, right? That he wasn't acting in self-defense. But I think the
grossly negligent in that he did what?
I think if you were evaluating this case without understanding, right, that accident during the course of lawful self-defense excuses it, I think, ordinarily punching somebody while holding a gun, right, would be grossly negligent. I don't think we dispute that conduct by itself, by itself would be grossly negligent. But what we're saying is that when that is done and it is a lawful act of self-defense to throw that non-deadly punch and an accident happens, that excuses the offense of involuntary manslaughter.
Is the gross negligence the throwing a punch while holding a loaded and cocked gun, or is it what the prosecutor seemed to be driving at with questioning? Was it that having determined that it was Mr. Harrison outside the door and acknowledging that he felt relieved at knowing that, he still, according to him, intended to have a gun cocked and stood in the threshold of the building with a cocked gun and didn't do anything to uncock it, if that's a verb, and remove that situation. Is it that, or is it throwing the punch while holding the gun? And it seems to me, and perhaps I'm wrong about this, the jury could have found that he was grossly negligent in going into the threshold of that building after finding out this was someone he knew, Mr. Harrison, and feeling relieved about it, i.e. no longer feeling like he needed to use the gun to defend himself against an attacker, and yet leaving the gun cocked. Is that the focus of the gross negligence? Or is it the throwing of the punch once Mr. Harrison began hitting him?
I obviously don't know how the jury was thinking about the case, but in terms of, was it grossly negligent to still have the gun in his hand? I mean, I don't think it was. I mean, I think under the circumstances where he has come to the door, he's disoriented, it's the middle of the night, he thinks there's an intruder, he thinks there's potentially someone trying to get into his daughter's room. He comes out, and yes, it's Mr. Harrison, and Mr. Harrison is acting erratically and violently. This is a man who has a alcohol level of 0.16, who's coming up the stairs at him, who seems angry that Mr. Payton hasn't answered his phone calls. And this is happening in a matter of seconds. And when Mr. Payton is saying, why are you coming, to my house 3 a.m.? We don't have that kind of a relationship. Mr. Payton is punching him. It seems entirely reasonable that, in this moment where everything is very unexpected and violent and erratic, that he still has the gun in his hand. And I want to emphasize, he's never pointing the gun. The judge finds he doesn't brandish the gun. He never points the gun at anyone. He never threatens anyone with the gun. He just has the gun pointed at the ground in his hand, which is how it was when he came to the door to investigate what was going on. So I think it would be hard for a jury.
So, Ms. Schneider, I mean, you're arguing the facts, which is all very interesting, but we're trying to get the law straight. I understand you to be saying, and this is what I understand you to be saying. So if I have this wrong, I want you to tell me. I understand you to be saying that the problem here is this: the jury found the jury convicted him because it found that that he caused the death of Mr. Jackson while acting in self-defense through gross negligence. And it didn't understand that because it was an accident during a lawful act of self-defense, the killing was excused, notwithstanding the fact of gross negligence. Is that your position?
I mean, I guess yes. I mean, I think they didn't understand that accident during the course of lawful self-defense excuses involuntary manslaughter.
Even if.
So they would have said no.
Even if the accident is grossly negligent.
But it's not. I think it's not. I mean, I think if it's during the course of lawful self-defense, then it's excused. I mean, I think it becomes not.
Because, well, you're saying
I think the lawful.
And a variation of your argument is, this cannot be right, I think, but maybe it is right. A variation of your argument is that an accidental killing in the course of lawful self-defense cannot be, as a matter of law, considered gross negligence.
I think that's one way to think of it. I mean, I think that's.
I want to know how you think. I think I'm trying to get what I think is the law. I don't think that can be right, but so I want to know, what your articulation of the law is. This is what I've been getting at. Well,
so sure. I mean, I think that the fact that he was acting in lawful self-defense, when the accident resulted that ultimately killed him, I think that, is defeating the notion that his conduct was grossly negligent. But I don't think that's clear to the jury without having the instruction, right? So the fact that it was lawful self-defense when the accident happens, that, yes, I mean, it defeats the notion of gross negligence, but the jury was entitled to have that explained to them in a defense theory instruction, and the way these instructions were given.
What should the jury, one problem is you never gave the judge a real instruction that would have actually clarified this. In fact, maybe we should ask you whether this claim is even preserved, but let's pass that for a moment. Can you tell me quite precisely, maybe this you can't do, but can you tell me quite precisely what the ideal correct legal instruction of accident as a defense to involuntary manslaughter in this case would have been, in your view?
I mean, I think, right, I think that it's, if the jury finds, you know, that Mr. Payton was acting in lawful self-defense when an accident occurred, he's not guilty of involuntary, I mean, he's not guilty of involuntary manslaughter.
Ms.
And I think
Schneider, this may be just another way of rephrasing the problem. But I don't understand how one can determine whether the self-defense was lawful without considering the nature of the so-called accident. Some accidents might be forgiven, others will not constitute lawful self-defense. And if it's a gross deviation that it creates an extreme risk of death, then it is not lawful self-defense.
Well, I think that this is really no different, right, than a case like Valentine, right, where what the court was saying is it was lawful to, it's lawful to instinctually, if you're responding instinctually.
Let me
to an
ask you
attack.
this question. How much deference should we give to Valentine? It's not binding on us. We've cited it before, but you rely understandably on Valentine. Maybe I'm not persuaded by Valentine.
So Clark, right, is binding on this court. And if you look at Clark, it quotes almost entirely from Valentine, right? It's almost entirely quoting Valentine, which in turn is quoting, you know, centuries of common law. And so we believe that this court expressly, you know, adopted the reasoning of Valentine and the reasoning of the common law when it chose to, you know, issue a holding based basically entirely on quotes from Valentine, right? I mean, I think it was a pretty express adoption of the reasoning, and there's really no principled, you know, reason why involuntary manslaughter would be different than second degree. And I want to emphasize that the government has cited no cases in which a court has held that the defense of accident during a lawful act of self-defense does not apply to involuntary manslaughter. All of the cases they've cited are talking about accident as a standalone defense, which is not at all what we're raising here. They have not cited any authority. We've cited Valentine, which is expressly adopted and relied on by Clark. And we think that principle is clearly established in the common law and is binding, you know, on.
So I think I understand your position to be that whereas involuntary, putting aside, let's put aside misdemeanor manslaughter. Okay, that's a separate category. Assume we're not there. I understand your position to be that whereas involuntary manslaughter is normally committed if the homicide is attributable to gross negligence, where the homicide, which is an accident, but it's grossly negligent, where the accident that causes the homicide occurs in the course of lawful self-defense, the gross, it is excused, even if it is gross negligence. It's a sort of an exception in your view.
Yes, it's yeah. I mean, I think
The
yes.
gross negligence standard of liability.
Yes, right. So it's different.
And I guess I would ask you, do you have any? Oh, I'm sorry. I don't mean to cut you off. You were going to qualify that?
No. I was going to say yes, and I was just going to say, you know, it would obviously be different if it hadn't been lawful self-defense, right? If Mr. Payton had just unprovoked, you know, punched somebody, wanting to punch them, right, but not to shoot them, not to kill them, and had a gun in his hand and it
In
went
other words,
off,
if what he is
that would not be excused.
if he's defending himself and what he is trying to do is use only reasonable force,
Yes.
then I mean,
Yes.
that's what would make make it lawful self-defense.
That's what
And
makes it
he
lawful.
didn't provoke it and all those other.
He didn't provoke it, exactly. And yes,
Then-
the jury.
Well, let me just think this through a second. So you're saying if those things are true, then regardless of how negligent, and he's not consciously doing it, it's an accident. Regardless of how negligent he is, how grossly negligent he is, it is the homicide is excused. And I guess so. The question I would ask is, No, that's possible. It almost makes it seem like an affirmative defense, which you certainly don't want to argue, I know you're not arguing, that the defense would have to prove rather than the government would have to disprove. But let's put that aside. So are you aware of any case law or any commentator authority articulating that position that in effect makes accident in the course of self-defense an exception to the general rule that gross negligence will support a conviction for involuntary manslaughter?
Well, I mean, I guess Valentine, right? And it's because I think it's because maybe this is just a different way of saying it, but it's because that lawful act of self-defense is really defeating the notion of gross negligence, right? I mean, without the self-defense, surely the act would be grossly negligent, but it's that lawful act of self-defense. You know, he's trying to meet the non-deadly force with non-deadly force. Now he has a gun in his hand because of the circumstances that brought him to the door, right? That's banging on the window, just as the defendant in Valentine had a knife in her hand because of the circumstances of cutting the flowers, right? So the attack sort of starts when you know, each of those individuals had a weapon in their hand, but under those circumstances, you know, when they are attacked and they respond with non-deadly force, I mean, I think probably everyone would agree, right? If the gun hadn't gone off, then that punching him back would have been a perfect exercise of self-defense, right? It's just that there was this accident that happened, right? And the shooting would not be pure self-defense because it would have been excessive, and he wasn't intending to shoot. He didn't reasonably believe, you know, his life was in jeopardy, but the pushing, getting him off, that by itself was a reasonable act of self-defense, and the gun in his hand went off just as that knife in Valentine's hand, you know, stabbed the decedent 6 times through the heart. I mean, I think this was frankly much more a feeling of accident than that. It was a single bullet, and you know.
So even though he had the gun not only loaded but sort of cocked on a sort of a hair trigger, you would say, and he brought it to the confrontation, you would say that none of that matters. It was grossly negligent. I mean, I think for your argument to work, you've got to say, I admit that was grossly negligent. But even so, and it was grossly negligent because anybody with a brain would know that if you get into an argument with somebody and the gun is in your hand, the gun is cocked and all the rest, bad things can happen. So, but even so, it was it was an accident that the gun went off as he was trying to defend himself, and the homicide is excused.
Yes, but I do want to say we would, and maybe this gets us a little bit into the other issue, but we would disagree that it's grossly negligent under the circumstances.
We're talking at
case,
a legal abstract level.
Sorry, I didn't quite catch that. I apologize.
I understand your position. We're talking at an abstract legal level, because I'm just trying to get clear in my own mind what I find a very difficult issue, which is what exactly is the legal standard here by which accident in the course of lawful self-defense might excuse a grossly negligent homicide.
Well, I think it's that the jury has to look at the facts of what happened and decide if the act was a lawful act of self-defense, and they can consider, right? They can consider the fact.
The jury was asked to consider whether it was a lawful act of self-defense.
They were, but the self-defense instructions they got made very clear the idea, right, of proportionality, and the idea that, you know, in order to use deadly force, you have to reasonably believe your life is in jeopardy. So it didn't work. And there was
no objection to those instructions.
Right. I mean, we don't object. Those are true if you're considering a pure self-defense theory. But I guess what I'm saying is they never understood. They had a defense theory instruction, right, that got across what defense counsel wanted, right? I mean, it got across, except that it was taken away with respect to involuntary manslaughter, right? So the defense theory instruction tells the jury, you know, that the government has not satisfied their burden of proving beyond a reasonable doubt that the firearm did not go off by accident while Mr. Payton was acting in self-defense. But then that instruction, which was a good instruction, was taken away from involuntary manslaughter. And that was by design, right? By the structure and language of the instructions. I think the government has conceded that. That was the entire reason that they asked for a lesser included on involuntary manslaughter, and they restructured those instructions. That was the intent of the judge, was to take away that defense theory from involuntary manslaughter. And that was the error here. And when you have a case like we do here, where you see, we had a really compelling defense of accident, during the course of lawful self-defense that was supported by the undisputed facts, and you have the jury, acquitting of second degree, acquitting of voluntary manslaughter, convicting of involuntary manslaughter, there's a very real risk that the jury, believed everything Mr. Payden said, but just believed that this was not a defense to involuntary manslaughter, and thought that essentially, Mr. Payden was defending against second degree and he was defending against voluntary, but his defense theory basically, ate the involuntary manslaughter, which was not the case. And, I think they could reasonably have come to that conclusion. I mean, the government was pushing very hard second degree. I mean, their theory was intentionality, right? And that's what they were pushing in closing, and that, and they made clear that sort of their backup was this involuntary manslaughter. And I think a jury reasonably would have thought, look, Mr. Payden is defending against those greater charges, but they wouldn't have understood that accident during the course of lawful self-defense also excused involuntary manslaughter. And that was by design in the instructions.
Well, perhaps we should, unless my colleagues want to ask a question, perhaps we should let you sit down, hear from the government, and see what it has to say about this, and then we'll get back to you. But if there are more questions, I don't want to stop anybody. Okay. All right, let us hear from the government, and then we'll give you a few minutes in rebuttal.
Your Honor, good morning, Michael McGovern on behalf of Appellee of the United States. The trial court did not err, let alone plainly err, when it instructed the jury. The trial court correctly recognized that accident does not excuse a charge of involuntary manslaughter, and appropriately structured the jury instructions to reflect that legal proposition. Indeed, appellant expressly agreed with the court's legal analysis and the proposed structure of those instructions. And I'll direct Your Honor to the February 14th transcript at approximately page 372. On appeal, appellant now advocates a new legal argument that was never presented squarely before the trial court, and that is that accident in the course of lawful self-defense constitutes a full excuse for involuntary manslaughter. That's not only wrong as a proposition, but was never presented before the court. For its argument, defense counsel relies upon Valentine in establishing that simply establishing accident in the course of lawful self-defense is an excuse without looking to the manner in which this lawful self-defense was being exercised. But that is not a correct reading of Valentine. In fact, what Valentine looked to when evaluating involuntary manslaughter was the manner in which what could be lawful self-defense was exercised, and found that in that particular case, there was no they called it negligence or recklessness. In our jurisdiction, we would refer to it as, Your Honor has been referring to it in shorthand, gross negligence, or gross deviation from a reasonable standard of care that created an extreme risk of danger, an extreme danger to life or serious bodily injury. And so the trial court's instructions correctly informed the jury that it could find appellant guilty of involuntary manslaughter if it found that he was not acting in self-defense, which they did find that he was not acting in self-defense, and if they found that his conduct was grossly negligent, which they also found. Those are the only two excuses that would have excused the unintentional killing. And because they didn't reach either of those excuses, his conduct was not excused criminally.
Mr. McGovern, I wonder if we confuse things by asserting that accident is not a defense to involuntary manslaughter. Wouldn't it be more accurate to say that, well, some accidents might be, but if the events constitute a gross deviation that creates extreme risk, then it cannot constitute a defense because that's part of the definition of the crime.
So 2 responses, Your Honor. First, the trial court never expressly instructed the jury that accident was not a defense to involuntary manslaughter. But the issue is that the concept of accident cannot be a defense to involuntary manslaughter because an accident, as the Red Book recognizes, is only a defense to the extent that accident shows the absence of a specific intent. That accident shows the absence of a specific intent to kill or a specific intent to injure, both of which are required for certain convictions under second-degree murder or voluntary manslaughter. But that's not the case. You don't have a specific intent mens rea element with respect to involuntary manslaughter. What the jury is required to find with respect to the intent or the conduct is that they were acting in a way that was a gross deviation from a reasonable standard of care. And so accident simply doesn't apply as a concept to that element, to that excuse. And
what
so
if the accident is a gross deviation from a standard of care that creates an extreme risk? Isn't the jury focusing on the elements of involuntary manslaughter, isn't the jury necessarily evaluating the type of, quote, accident, end quote, that occurred? And if it's not a gross deviation, then the defendant's not guilty.
that's correct, Your Honor. So to the extent that there is an accident that was simply negligent, the jury wouldn't convict because they're being instructed they can only convict in circumstances where the accident rises to a gross deviation from a reasonable standard of care. So it's essentially baked in. The concept of accident and when it is or is not a defense is baked into the instruction on what standard of care the appellant must have been acting in, or that the government must prove that he was not acting with a particular standard of care.
Ms. Schneider seems to be arguing that where the person is acting in lawful self-defense, and the accident occurs, it is an exception to the general rule that gross negligence, as I use the term, would make one guilty of involuntary manslaughter. In other words, the pressures, the theory must be something along the lines of the pressures of responding to an attack and acting in lawful self-defense, which is to say intending only to use reasonable force, excuse even gross negligence.
And so, Your Honor, as a legal matter, if that were the case, then it would run counter to the cases which have determined that even where a defendant is justified in using lawful, lethal force in self-defense, if another individual is injured, rather than the person against whom...
that's an intentionality situation. In other words, well, maybe I misunderstood the example you were given. I mean, this is what I'm saying, and what I understood Ms. Schneider to be saying is somewhat different from the notion that self-defense does not permit the excessive use of force in response to a non-deadly attack, for example.
No, Your Honor, I believe I'm saying something.
You cannot intentionally use more force than you.
Your Honor, the logical underpinnings of Ms. Schneider's argument, as you have advanced it in your question, are that lawful self-defense in and of itself may not be gross negligence, that it cannot reach the standard of gross negligence, because if one is acting in lawful self-defense, that simply is never grossly negligent. But there have been cases where individuals are found to be acting in lawful self-defense using lethal force where they are legally, lawfully permitted to do so, and yet grossly negligently cause the death of someone else. And that death and the causing of that death is not excused and may be involuntary manslaughter, where the manner in which they were exercising their lawful right of deadly self-defense was done in a grossly negligent manner. And those cases, if it were true that lawful self-defense equates to non-grossly negligent conduct, those cases would not so hold. And we cite
What
those cases.
cases are you citing? What cases are you citing to?
And Your Honor, I don't have the page in my brief, but we do cite them. I believe it's, we do cite them in our brief, and I have to refer you to that. But so there's a recognition there that what matters is the standard of care that one is using in the exercise of self-defense. Not only that, but Ms. Schneider's argument continues to be premised upon the concept of one acting in lawful self-defense, that it's necessary that the self-defense be lawful. Here, the jury rejected the concept that the appellant was acting in lawful self-defense. It found that the amount of force that he used in which resulted in the shooting and then death of the decedent was either not proportional or was not permitted, because self-defense itself was not permitted, which leads to the second issue.
In the cases that you're thinking of, does the gross deviation from the standard of care have to come during the exercise of self-defense? I was trying to get at this with Ms. Schneider before, because it seems to me that one could think that the gross deviation from the standard of reasonable care came when relieved because he no longer thought it was a robber or a burglar outside, knowing it was someone he knew, Mr. Harrison. He used the word relieved, defendant did. Relieved, he still went into the threshold of the building once his wife opened the door. And he said he intended, even then, to have the gun cocked. And so he goes to what is now the confrontation he originally anticipated, to a meeting with someone he knows, and he leaves the gun cocked. And it seems to me that that could be regarded as the gross deviation from the standard of care, and that it need not focus on whether when he returned a punch, he did so with a cocked gun in his hand. But does the case law contradict me on that? Does the case law say that the gross deviation has to come actually during the exercise of self-defense?
And Your Honor, I don't know specifically the answer as to whether the case law speaks specifically to the timing issue. The government's position would be that the totality of the circumstances, both how he came to the interaction with him and his conduct during the course of the defense, were all grossly negligent. It was grossly negligent when he came there, and it was also grossly negligent in the manner in which he deflected himself. So the government's position would be that you could find both occurred here, and that the jury convicted because his total conduct in the manner in which he defended himself, if he was defending himself.
Right. I ask only because it seems to me it takes nothing away from the notion that he was lawfully engaged in self-defense to say that nevertheless the killing is not excused because there was just before that this gross deviation of bringing.
And Your Honor, I think those concepts also play very much into the other issue with whether or not it was appropriate to instruct the jury that he could not be acting in lawful self-defense if he had provoked the attack, and that a gross deviation of the standard of care there could be used and to show the appropriateness of the provocation instruction, that he was in fact doing something that he reasonably should have known would have provoked a violent incident that ended up causing harm. And so the way that you framed it as gross deviation could also play into whether or not self-defense was even available to him in the first place through the provocation instruction that was given.
I'd like to clarify one aspect of your position here. We've been throwing around the term lawful self-defense, and I think it gets used with different meanings by different people at different times. If Mr. Payton was simply intending to push Mr. Jackson off him after Mr. Jackson punched him, not intending to shoot Mr. Jackson, which would be an escalation to excessive force. The fact that accidentally the gun goes off in the course of that pushing and kills Mr. Jackson. On one level, you're right. It's not. If that shooting was not an act of lawful self-defense. It wasn't really, you could say, an act of self-defense at all because it was unintended. It's just an accident or a fortuity that happened during the exercise of, you could say, of lawful self-defense. On the other hand, it might have been, I mean, the real argument is that even if it was an accident, it doesn't get you where you want to go because of your gross negligence in that conduct. So we don't really know. I mean, it's funny, the jury doesn't, as I understand it, the jury presumably could have made exactly that finding. It could have said, look, we're not, the issue before us is not really whether shooting was a lawful act of self-defense. Nobody claims that. The issue is whether he had the right to defend himself, and while doing so and while attempting to do so lawfully, he acted in a grossly negligent manner. And that, I understand, is the government's theory. Whereas appellant's theory is that it seems to translate into, if he's defending himself, you can't logically find that the accident of the gun going off was grossly negligent. And that seems to be the difference, the main difference between your position and the defense position. Do I understand that correctly?
I believe so, Your Honor. I believe that one thing that the jury was instructed not only about the use of deadly force in self-defense, but the use of proportional force in self-defense. And what's important to note is that the jury was specifically instructed that they were to look at the force that was used and determine whether or not that force was reasonable under all of the circumstances. And those circumstances must necessarily, when evaluating a claim of lawful self-defense.
The whole premise of involuntary manslaughter is that the force was not reasonable. It wasn't even intended.
Correct, but the jury found that the force that was used was disproportionate, or the jury found that he didn't act in self-defense, as self-defense was defined to them. But I was highlighting for Your Honor that in the definition and instruction on self-defense, it was made very clear that an individual has the right to use as much force as is proportional and reasonable to respond to the threat that they are confronted with. And that, in considering whether or not that you are using the proper amount of force, or a reasonable, amount of force, you should consider all of the circumstances. And so the jury presumably considered all of the circumstances. It considered the fact that there was a gun. It considered the fact that he didn't put that gun away when he saw the individual. It considered the fact that he was, according to the two ear witnesses, the primary aggressor in the situation, that was the one that was in a heightened, anxious state, while the victim was the one who was trying to calm him down. It considered the fact that the victim was not armed. It considered the fact that the victim had under his fingernails DNA, which were potentially consistent with him trying to grab a wrist that had a gun pointed at him. And it determined that in the totality of those circumstances, the force that ended up being used was not reasonable, and therefore there was not a lawful claim. Either was not reasonable because there was not a lawful claim of self-defense, or that the defendant was not even entitled to defend himself because he forfeited that right by provoking the situation, which goes to the second alleged error. But either way, they were instructed about what does constitute lawful self-defense and what amount of force would be able, and told that they were to consider all of the circumstances. And all of the circumstances would include whether or not he acted in a grossly negligent manner, and whether or not acting in a grossly negligent manner can be reasonable force.
Do you think that the way the jury was instructed it understood that even though the shooting was not justified as a matter of self-defense, that did not necessarily mean he was guilty of involuntary manslaughter. If the shooting was only an accident and not grossly negligent.
I do believe so, Your Honor, because the government had to disprove self-defense, but it also had to prove, according to the instructions, but it also had to prove that his conduct was grossly negligent. So the jury necessarily made a finding that in the circumstances of the interaction between the decedent and the appellant's conduct was grossly negligent, and it was that grossly negligent conduct which did not itself constitute self-defense, or self-defense as the law allows one to defend oneself, was grossly negligent and caused the death of the decedent. And so therefore, could not be excused from criminal liability for the death. And for that reason, we believe that the instruction with regard to involuntary manslaughter was correct.
Now, why do you think the instruction on provocation was appropriate?
I'm sorry, Your Honor?
Why do you think the instruction on provocation was appropriate?
Your Honor, the circumstances allowed the jury to determine that the appellant was the individual who was the first aggressor or who provoked the situation in which the appellant and the decedent found themselves. The facts are that in the middle of the night at 2 a.m., there was a knocking on a window, which, according to the testimony of one of the ear witnesses, was not necessarily a strange event for this particular appellant, given that that was the manner in which these individuals announced that their presence to him on prior occasions, because it was a multi-unit dwelling and there was no way to knock on the door without entering the actual unit. So there's a knocking on the window. There's no indication in the record that there is any reason to fear any sort of intrusion into the home, any reason to fear any sort of threat, that there's any threat being made to him. In fact, there is evidence that he would have known who was at the door, both before he went to the door with the loaded gun and after he arrived at the door with the loaded gun before he opened the door. And that is, there were 4 calls that were placed to this individual. He knew that the decedent was trying to get in touch with him, was trying to talk to him, and he was intentionally ignoring him all day and in the early morning. So he was aware that the decedent was trying to get in touch with him. Someone knocks on his window, which is not an unusual occurrence according to the testimony of one of the ear witnesses. He arms himself, takes the safety off of that gun, goes to the door. He asks who it is at the door. Then, once it's confirmed that it is in fact the decedent, someone with whom he is upset for having stolen from him in the past, and someone he is now upset with for having disturbed him at 2 a.m., opens that door, crosses over the threshold with a loaded gun that he does not put away, and gets into an altercation with that individual where, by all accounts from both of the individuals in the car, he was the only one whose demeanor was aggressive, while the decedent was trying to calm the situation. And so under that view of the facts, all of which was in the record, it was perfectly reasonable for the court to find that it was up to the jury to determine whether or not appellant was either the first aggressor or had provoked the situation in which he found himself, which was an individual who, trying to calm him down and confronted with a gun, may have grabbed onto his arm, there was a tussle, and the gun went off. And so in those circumstances, the instruction was perfectly appropriate. We'll also note that—
One reason I'm uncertain about this is because the instruction itself says that mere words do not constitute provocation.
But here, Your Honor, I believe that there are—
Go ahead, I'm sorry.
Are more than mere words. Here you have an individual who is affirmatively coming to confront an individual, does so in an aggressive manner, and does so while armed with a loaded and cocked, ready-to-fire pistol.
Well, tell me again, what was the aggressive— I mean, The individual wanted him to come to see him, so the fact that he went to see the individual hardly can be considered provocation. But he did go with a gun. What was the aggressive manner again that you think he displayed?
So there's no testimony as to exactly the physical manner in which he was being aggressive, but the tone and demeanor as described by both of the individuals in the car were that he was the one that was aggressive and being loud, speaking loudly, speaking angrily to the appellant, to the decedent.
The speaking angrily, see, I'm thinking to myself, the decedent knocks on the window. The decedent says, I want to talk to you, basically. That's what the knock was. Okay, objectively speaking, Mr. Payton comes out to talk to him. Does exactly what the decedent wants him to do. Now, the decedent didn't want him to bring a gun, okay, but he didn't point the gun at the decedent. And if mere words, I mean, who wouldn't be angry at 2 in the morning, you can say. I just wonder whether there's enough here to really establish that a factual foundation for a finding that Mr. Payton was aggressive or provocative within the meaning of the doctrine.
And
yeah,
Your Honor,
he was angry. He was. I don't know if he was yelling. I don't know if there's testimony about that. But he was angry and he was annoyed, and he said some harsh words to Mr. Jackson. Is that enough for provocation?
But Your Honor, you don't just have that he was angry, annoyed, and said some harsh words. You have that he armed himself and readied that. Not only armed himself, not only brought a gun or a weapon, but brought one in a state that was easily accessible and ready to be used. And so I do think that circumstantial evidence that reflects upon what the
Have you been following Second Amendment jurisprudence recently?
state of mind.
Have you been following Second Amendment jurisprudence recently? It seems to be de rigueur to carry guns in the event of possible confrontations. I don't know if merely carrying it gets you quite where you want to go.
But Your Honor, you have not just merely carrying, you have an individual who arms himself in preparation for a confrontation, for a situation where there is no external indication that there is going to be any danger or going to be any confrontation. And yet he is the one that is bringing the weapon, that is escalating it there. And in some ways it is very similar to the decision, and I apologize.
You want to cite Andrews, but there are distinctions. Right? You want to cite Andrews? Is that Brandon Andrews?
I believe Andrews is very much on point here, but I also believe what's important is it's a DC Circuit case upon which Andrews and a number of other of these cases law rely. And it's a situation in which in the backyard, the defendant goes to confront an individual who is defacing or taking windshield wipers from a disabled car that is slightly beyond the fence. And he walks to the outside. There's an altercation between those two. He goes back inside, gets the gun, comes back out, and then when the other individual comes towards him, he shoots him in what he calls the self-defense. And under those circumstances, even where the individual remained on his property, even where there was actually more evidence here that there was going to be a fraught interaction with the individual, he went and armed himself, ratcheting up the nature of the disagreement, and it was found that provocation was a viable instruction in that case. And so,
do you remember that was a DC Circuit case?
Yes, Your Honor, and it was older. It relied upon Laney and the others, and I apologize for not having it.
That's all right.
Mr. McGovern, could you help me with this? One might think that what precipitated fatal was Mr. Harris's decision to punch Mr. Payton. And that seems to have been provoked only by words. You're not my friend, you're only my Uber driver. How, in your view, did Mr. Payton provoke the punch?
Well, Your Honor, that is taking the evidence, that is crediting the testimony of both the appellant and his girlfriend, who was shown had a bias in his favor. But in addition to that, you have the fact that he was making these statements as he was armed with a gun, as he was holding a firearm. And there was also evidence that under the fingernails of the decedent, on his left hand, there was DNA that matched the appellant, which the forensic scientist testified would have been consistent, not with, because of the amount, not with simple touch or brush DNA, but with something like grabbing or having grabbed a hold of someone's arm. And so a jury reasonably could have inferred that, in fact, this gun was a focus of the decedent, that what prompted the decedent to punch or push or in some way move towards the appellant was his feeling that he needed to defend himself against this weapon that was involved, especially where the other testimony about the demeanor as to the people that were listening and observing from the car, that it was the appellant who was, in all respects, the only person who was upset, while it was the decedent who was trying to calm the situation, who was trying to get the other individual to calm down. And so in those circumstances, there was a view of the facts that permitted the jury to find that, in fact, the appellant had been the first aggressor and had provoked the situation into a violent situation. We would also note that in its brief before this court, appellant doesn't actually take issue with the provocation instruction on that theory of law. Rather, it states that a different standard should apply because the provocation occurred within the home, and says that one has to intentionally provoke. Not merely do they need, whereas the standard under Laney and this court's decisions for whether a provocation instruction is correct is whether or not an individual is aware that, goes looking for trouble, or knows that their presence is likely to cause trouble. But appellant is attempting and says that the reason this instruction, on appeal they say the reason this instruction was error, was because there was no evidence that he intended to provoke. And that is the substance of their argument. And the fact of the matter is that's an incorrect legal standard. So they haven't even preserved an appeal of whether the circumstances amount to a provocation, and have waived that issue. And as we argue in our brief, we believe that even if you were to reach that argument of the intent, it would need to be reviewed on a plain error standard. We disagree with their standard of the law. We don't believe that one has to show an intent to provoke in order for the provocation instruction to be given here. We believe that that's an erroneous statement of the law. But even if this court were to find that there was some difference of when a provocation instruction is appropriate, given where the provocation occurred, it's the government's position that you would have to find that it was plain error. There are no further questions. We would ask that the court affirm the judgment below.
Okay, I'd like to just very briefly, Judge Glickman, I can't hear you.
I apologize. We'll give you a little bit of time on the first issue, the accident, but we'll give you a little more time on the issue that arose only in the appellee's argument of provocation.
Thank you. I appreciate that. So on the first issue, I just want to try to sort of clarify the interaction between gross negligence and self-defense. So our position is that when an accidental killing results from self-defense, that conduct is by definition not grossly negligent. And that's because self-defense means that the defendant is acting under duress, right? To the extent his conduct is not super careful in the way that it might be if he were not acting in self-defense, it is excused. The government has not cited a single case in which some court has held that accident during lawful self-defense was also grossly negligent and that involuntary manslaughter was not excused. The jury was not instructed on, on the concept of lawful self-defense during or accident during the course of lawful self-defense as it relates to involuntary manslaughter, and this was very prejudicial.
Is this an argument that was made to the trial court that when an accidental killing results from self-defense, it cannot be gross negligence because the person is under duress and the circumstances are such that
Well, I think not as refined as today, but the argument that it is that accident during the course of lawful self-defense is a defense to involuntary manslaughter, that was made to the court. And I think, if you look at sort of the course of those 4 days worth of instructions, it was always very clear that defense counsel's defense theory was accident during the course of lawful self-defense. And then, on the eve of closing argument, when the government asked for involuntary manslaughter as a way to get around it, defense counsel came back the next day and said to the judge, it is a misstatement of the law to say that to just say accident is a defense to these two offenses and not the third, and be tailored to the facts of the case, and sort of made clear that when a decedent has caused the scenario, right, that required Mr. Payton to use self-defense to repel an attack, that accident is an essential part of the defense. And I think that the judge was well aware that defense counsel believed that his defense theory applied to involuntary manslaughter and ruled against him. And of course, we're entitled to refine that argument on appeal.
Now, Mr. McGovern recalled that in his brief, he had cited some cases which, simply put, reject this contention because they appear to hold, if I understood him correctly, that gross negligence, that an accidental killing even in self-defense can be gross negligence such that the killing is involuntary manslaughter. Are you aware of those cases? Have you addressed them in your brief?
I am not. I am not sure what he's referring to. I know they tried to make an argument around Valentine and to that respect, and obviously that's not how Valentine came out, and we believe it stands for the opposite proposition. I believe the cases that were cited were focusing more on accident in isolation as opposed to as an amalgamated.
I beg your pardon. Accident in
isolation as opposed to as a hybrid defense. So I'm not sure if he's just relying on.
I got it.
I'm not 100% sure, but we are not aware of any cases that hold that the standard, for self-defense, is different depending on, the level of the offense charge.
I'll just point out, it's one thing to say that when a person is acting in self-defense and under threat, the conduct that would, in other circumstances, amount to gross negligence are not, for precisely the reason you stated. It's another thing to say that as a legal matter, the two things simply cannot coexist, and you cannot have even any possibility as a legal matter of an accidental infliction of harm in self-defense that is the result of gross negligence.
I think
you see the distinction?
Yeah, I think our response is that the case law is right. The case law is clear that a lawful act done in a lawful manner is not involuntary manslaughter, and a lawful act of self-defense is by definition a lawful act done in a lawful manner. And that is, it's evaluated by standard of reasonableness, but it's different than how it would be if you weren't under arrest, because the case law recognizes that we look at the situation in terms of how it appears to the defendant at the time under the duress, acting in the minute. And so if it's a lawful act of self-defense that defeats, it's a lawful act in a lawful manner and it defeats, gross negligence. And now if I may turn to the Laney issue.
Turn briefly to the provocation issue since it came up.
Great, thank you. I want to emphasize that this court has never extended the rule of Laney, the rule that you forfeit your right to self-defense if you have reason to believe that your presence will provoke trouble, to the home. And doing so would eviscerate the core of the right to self-defense. The Laney rule, in essence, is about traveling to a place where you are likely to meet an adversary and where a confrontation is likely to ensue. In that context, the DC Circuit in Laney adopted an outlier rule that mere presence can be provocation. That rule has never been applied in the home, and it's not sound in the context of the home where an intruder comes to you and threatens your sanctuary. I mean, I think Laney, if you look at the text of Laney itself,
What if the intruder doesn't come to you, but you open the door to your home, walk out into the hall, open the door to the building, and come to the intruder?
Well, I think
the would-be intruder.
I think what we have, Mr. Payton had a right to investigate that knocking on his window, right? His child's bedroom window, there was banging on the window, 2 a.m. He has a child sleeping in there. It was an unsecured window. We know that there's testimony that the gate on it was broken. Anyone could pull it open. He has a right of anticipatory self-defense to see to see what's there, hoping for the benign. You're hoping it's the teenage prank, on your window, but you have every reason to fear that there is an intruder coming into your home where your family is. He had a right to go to the door and investigate. And I would say this is really analogous to the situation I think we're all more familiar with, which is the single family home, right? 2 stories, the family's on the 2nd floor. You hear you hear a sound downstairs. You're hoping it's the relative who's come over unexpectedly with their key, but you're fearing the worst. Maybe it's a home invasion, right? Dad goes downstairs to investigate. Who's down there? Doesn't know. Could be the worst case. Grabs whatever there is, right? A gun if he's a gun owner, baseball bat, fire poker, whatever. Just ready, just in case it's the worst. I mean, this was the apartment dweller's version of that. The only way for Mr. Payton to see what that threat was, potentially the home invasion coming into his house, was to open the door, which is what he does. And he takes the gun so he's ready for the worst case, in case it is that worst case scenario. He has it, but he's not pointing it. He's not threatening it, but he has it ready. And that's really.
Can I ask you a question about this? You have predicated your argument on the most defense favorable view of the facts at trial. Conversely, Mr. McGovern defended the provocation instruction here by saying that, looked at from the point of view of the government's evidence, it had a somewhat different cast. I won't try to repeat all he said in his argument, but it's in that brief as well. If we view the evidence in the light most favorable to the government, does that change in your view, the question of the propriety of the provocation instruction?
No, I mean, Mr. This was his home. There was banging on the window where his daughter's sleeping. He had a right to investigate what it was, and he had a right to anticipatory self-defense to be ready just in case. I mean, we don't think the evidence really supports the finding that he knew it was Mr. Harrison, but even assuming for the sake of argument that he did, I mean, this was very erratic behavior. I think the testimony of his girlfriend was, yeah, we've knocked on the window before, but we've always made arrangements first. This was unusual to not have, had a pre-planned meeting. That's what the girlfriend testified to. So it's 2 a.m. His daughter's asleep. There's banging. Even if he had reason to think it was Mr. Harrison, which we again don't think that the evidence support, this was out of the ordinary, and this is it's erratic behavior. It's somebody who is apparently a very heavy drinker. He's got alcohol level of 0.16. He's a known drug user. I mean, it is a sort of suspicious and an alarming set of circumstances, and he was ready. He was entitled.
He testified
to be prepared
at trial
for the worst.
He testified at trial, I think, that once he saw who it was, he was relieved.
He did. And then he felt initially relieved, and then Mr. Harrison escalated things by saying, by angrily saying, why are you carrying me? Which means, why weren't you answering my calls? Why are you disrespecting me? He comes up the stairs, he's angry, he's drunk, he's belligerent. Mr. Pate says, you're just my Uber driver. We're not friends like that. And Mr. Payton punches him. It all happens very fast. The judge found that there was no evidence that Mr. Payton threatened him, didn't brandish the weapon. I mean, he had a weapon with him, just as you're entitled to do in self-defense. And I think it's worth, noting that in Heller, one of the reasons why the DC law was struck down was not just about having a gun, but also about the trigger lock requirement. Because what the court said is that, self-defense is meaningless if you can't be ready to act on it. So I don't think it was unreasonable at all that he has a gun and it's ready to use if he needs to. I mean, it's what police officers do every day when they feel that they're being threatened. They have that gun ready. They don't have it locked, because if it's locked, you can't use it when you need to. So he was prepared, but he doesn't do anything aggressive. And instead he is attacked. But I think the real fundamental point here is that the instruction that was given was this incredibly broad instruction, right? It says, one who deliberately puts himself in a position where he has reason to believe his presence will provoke trouble cannot claim self-defense, right? And so the jury, I think, applying that instruction, a jury can find, well, if there's, an intruder coming to your home and you go out to investigate or protect your family, or, just see what's going on, say, go away, get out of here, you should have reason to believe that your presence in doing that, there's a risk it's going to anger that intruder, or anger even that belligerent drunk friend who's come over, that there's a risk. And so now you've forfeited your right to self-defense. I mean, that would be a complete evisceration of the right to self-defense when you are in your home, your sanctuary, right? Mr. Trouble has come to him. And so giving that instruction, basically tells the jury that he had to just, no matter what the threat was, had to stay in his home as a sitting duck and can't do anything until this potential intruder comes through the window or does whatever, a drunk belligerent, Uber driver does. And that would be an extension, a vast extension of Laney. We think that's contrary to Beard. We think Beard precludes such an expansion. But it would take this court's law of self-defense even more out of sync with the other 50 states, none of which have endorsed this Laney rule. And so we think that this was hugely prejudicial error and ask the court to reverse on that ground.
Okay. All right. Well, thank you. Thank you both, counsel. We have your arguments and the case is submitted.
Thank you.
Okay, we'll call the third case, Robert Arthur versus United States.
Hugely prejudicial error and ask the court to reverse on that ground.
Now, let's see, Ms. Schneider, we still see you, although maybe you're frozen. I think you're frozen. We're having trouble finding Mr. McAvoy, I guess.
Okay. I'm trying to make sure I can turn off all of my phones, so sorry.
Here we are. Here's Mr. McAvoy. Okay, we've called the case Mr. McAvoy, Arthur versus United States. Mr. McAvoy, you may proceed.
My apologies, Your Honors. May it please the court, Brian McAvoy on behalf of the appellant, Mr. Arthur. I'd like to reserve 5 minutes for rebuttal arguments. Your Honors, the appellant, Mr. Arthur, contends that DC's Sex Offender Registration Act, or SORA, is unconstitutional as applied, as it violates the ex post facto clause. Accordingly, the appellant requests that this court reverse the trial court's denial of the appellant's motion to dismiss due to ex post facto violation, dismiss the charge of failure to register, and find the application of SORA to Mr. Arthur unconstitutional. Or in the alternative, reverse the denial of the motion and remand for rehearing. Your Honors, the appellant wishes first to address the issue of unconstitutional ex post facto punishment as applied under case law. And second, why the facts of this case make clear that SORA is unconstitutional as applied as to Mr. Arthur. Under the Supreme Court analysis in Smith v. Doe, a legislature may assemble a statutory scheme intended to be deemed civil and yet be so punitive in purpose or effect as to deem it unconstitutional as applied. The key weighing factors utilized in Smith, in this court's In Re WM, and the Sixth Circuit's Snyder v. Doe are whether the statutory scheme, first, has been regarded in our history and tradition as a punishment, a key aspect of which is the concept of banishment. Second, imposes an affirmative disability or restraint, importantly, physical restraint. Third, promotes the traditional aims of punishment. Fourth, has a rational connection to a non-punitive purpose. And fifth, is excessive with respect to this purpose. While counsel won't review the full depth and breadth of these factors as present in this case and outlined in appellant's brief, I will highlight those particularly poignant factors. The Supreme Court applied these factors in Smith and found that based upon the factual record in that case, Alaska's statute did not impose excessive punishment. And yet that same Alaska statute was later held to violate the ex post facto clause of the state's constitution.
Mr. McAvoy, I wonder if you would clarify for me your position about reconsidering Doe and WM. You emphasized that those cases were based upon the records presented in those cases.
Yes, Your Honor.
One could say that every record is different in every case. Does that mean there is no such thing as binding precedent in this area? And that any time a defendant makes an ex post facto argument, it has to be examined from the beginning?
Your Honor, no. The position of the appellant is that the precedent consists of the weighing factors announced, and that those weighing factors should be weighed in the individual case. In the present case, as explained in the brief, and as I hope to expand upon, those weighing factors in the present case weigh heavily, especially with respect to housing considerations, the requirement that Mr. Arthur appear in person, and as the understanding of those underpinnings of the SORA law in this case and across the country has changed with respect to studies of recidivism and the sharing of this registration information as access to that information grows.
Let's talk about recidivism for a minute. Do you want us to say that when the Supreme Court emphasized that in the Doe case, they were relying on faulty science, and therefore we will make a judgment that as of today, that is simply wrong? Or doesn't somebody have to conduct some fact finding on that issue? Either a legislature or a trial court?
Your Honor, yes, the position of the appellant is that some of that information that the Supreme Court did rely upon was faulty. And additionally, some information submitted in this case argues against that position, while it is our position that this court does have the ability to take a closer look at that. In the alternative, again, we do believe that it would be proper to remand for further rehearing on that. But ultimately, that is a power that is before the court and in the realm of this court.
Mr. McAvoy, go ahead, Judge Fisher.
No, please.
If you're following up on that question, please do go.
Do you think the present record would entitle us to say that your client wins on the issue of recidivism?
Your Honor, not on the issue of recidivism alone, but as a weighing factor, yes, that is another weighing factor that argues strongly for the SORA law to be unconstitutional as applied to Mr. Arthur.
Judge Thompson, thank you for your indulgence.
Oh, thank you. I didn't want to cut off a follow-up question. Mine is a different question. As you know, Mr. McAvoy, the case law tells us that for your client to show that as applied to him, the registration statute is unconstitutional and punitive, that he needs to come forward with the clearest proof of that. So I have a couple of questions that go to that. And the first one is, for the period during which he failed to register, that period from some date in 2015 to 2016, or I may have the years wrong, but you know what I'm talking about. Is it important, is it critical that he have proof that during that period, the registration statute operated in a punitive way, or does that not matter? And the second part of the question is, if it does matter, what is the clearest proof that he has come forward with that during that period he was affected in the way he claims? Because of course, there is evidence in the record that he was precluded from being a live-in aide for his mother, but that evidence is from 2017, after the period in question here. And there's a claim that he lost employment because he needed to register. And as to that, I didn't see any proof in the record, but could you answer the question about whether it's crucial that he show a punitive effect for the period during which he failed to register?
Yes, Your Honor. Our position is that all of it matters, though the clearest proof is a combined weight of all of the weighing factors. And as to some of the aspects, the appellant would concede that there was not perhaps a full hearing as that motion was denied, but the position of the appellant is that on those aspects that are currently before the court, such as the denial of housing, again, the requirement of in-person registration, and those aspects with respect to recidivism, that there is clearest proof that it is unconstitutional as applied.
So what there is for that period is the need to appear in person. There is that, but what else is there for that period during which he didn't register? Because I don't think there is any proof or even any proffer of what would have been proven as to housing. And I saw, as I said, no proof about employment, but perhaps I'm mistaken as to that, and you can correct me.
Yes, Your Honor. During that period and on the record overall, it is the position of the appellant that the overall weight of the evidence is that clearest proof. Though again, some of that specific proof during that period may have been precluded by the inability to have a full hearing on the motion.
Yeah, I appreciate that the trial judge did not hold a hearing, but that didn't stop your client from coming forward with the evidence about the live-in aid. And so was there a proffer on employment or just an assertion that he lost his job because of the registration requirement?
On this record, there is no precise proffer, no, Your Honor.
What is the current situation about housing? Does his mother still live there? And does she still need him to act as her caretaker?
Yes, Your Honor, she does, and that is both of their wishes. The current state of that petition is still pending before the Housing Authority. But again, that is their desire, and one of the strong weighing factors as the position of the appellant.
Of course, there's nothing in SORA itself that precluded him from moving in to help his mother. Is it fair for you to attack the SORA legislation by relying upon regulations passed for other purposes by other bodies?
Yes, Your Honor, we believe that it is, because but for SORA, that application of those regulations would not apply. This is true of other aspects, and they become part of the full constellation of restrictions that one registered under SORA must live under, and is part of why the SORA law is unconstitutional as applied.
But aren't we supposed to be looking for clear proof that the legislature got it wrong, although it had hoped to create a civil regulatory framework, not punitive? And if these circumstances developed after the legislation was passed, why do they bear up on the validity of the legislation itself?
Yes, Your Honor. Our position is that it bears upon that analysis because it is that impact as applied to Mr. Arthur and to other registrants. It, again, may not have been the intent of the legislature, but measured as applied, those laws, those regulations, including the private employers that may make those decisions on the basis of that. All of those go into the weighing analysis as to whether it is unconstitutional as applied.
You point to the in-person reporting requirement as one of the burdens and restraints. But of course, there is that footnote in WM, which points out that given the small size of the District of Columbia, the requirement for in-person reporting is not really so onerous. So that having been addressed in WM, what do you have to say that makes that point worthy of consideration here as an important factor?
Yes, Your Honor. Mr. Arthur would nevertheless be compelled to physically appear somewhere. And it's our position that that is in itself a physical restraint.
I mean, is that an open point after WM? Perhaps some of these others are, because those facts of that type were not an issue there.
And Your Honor, perhaps it weighs differently as to whether someone in another jurisdiction may have to travel further, but it is no less a physical requirement. And in that sense, it is comparable to a physical restraint, or actually is a physical restraint. As the Snyder case stated, this may not be the cold irons clasped around wrists dragging him to this appointment, but it no less applies with the force of law and the threat of further punishment, similar to parole. It is the position of the appellant that is both a physical restraint and analogous to parole in that sense. The Supreme Court in Smith, in fact, conceded that the argument regarding similarities in the restraint imposed by registration requirements and probation, quote, has some force, close quote, but ultimately dismissed it because the facts in Smith did not involve in-person registration, whereas Mr. Arthur must register in person, quarterly in fact, and this is a particularly important factor as Mr. Arthur does not have the freedom of movement with respect to these meetings and faces criminal penalty for failure to move and appear as commanded.
Why is appearing quarterly in a small jurisdiction like the district so onerous? Maybe if you had to show up every day in person, it would be more compelling. But once a quarter, that's not a problem.
And Your Honor, there may be other jurisdictions where, again, that may be more onerous, but it is no less onerous as to that particular time when Mr. Arthur is required to appear by force of law and with threat of punishment. Under that weighing factor, as made clear in precedent, this is a physical restraint. Additionally, Your Honor, as it is increasingly difficult to move about, and as we conduct these arguments over Zoom, the ability to move around is perhaps something that is not, to be taken for granted.
I take your point.
Your Honor, that we believe is part of the physical restraint. I do see that my time has elapsed, so the appellant contends that the facts in the present case amount to punishment in violation of the ex post facto clause, and asks this court to reverse and dismiss Mr. Arthur's conviction for failure to register and find SORA's retroactive registration unconstitutional as applied to Mr. Arthur, or in the alternative, to remand for rehearing on the weighing factors discussed in the motion and the brief. If the court
Thank
has
you, and we'll give you a few minutes in rebuttal.
Okay. Thank you, Your Honor.
Let's hear from the government.
Good morning, Your Honors. May it please the court. My name is Chris Ellen Kolb. I represent the United States in this matter. Your Honor, this court and the Supreme Court have squarely held that requiring convicted sex offenders to register under SORA does not violate the ex post facto clause. Appellant has focused on the nature of his particular circumstances as a basis to revisit that decision. And in addressing this as applied nature of his challenge, I'd like to step back a little bit and acknowledge that I think the briefs, mine in particular, probably elided over some of the subtlety of what an as applied challenge means in this context. We cited in our brief the Garner case, the Supreme Court case involving parole and the timing of parole hearings. And in that case, the court does say that they wanted to look at as applied to the defendant's sentence. However, the Supreme Court in Garner was looking at the practical implementation of that particular provision and whether or not there was clear proof that there was a punitive intent behind that particular statute in Garner. In Garner, however, the court, I think, was looking at the practical implementation writ large. And I must say, and I shared this case with Mr. McAvoy last night as I was drilling down to try to make sense of this. There was a later Supreme Court case, which we didn't cite, and I will provide the court, and I did provide it to Mr. McAvoy, called Selling versus Young, SELING versus Young, 531 US 250 at 262. And the Supreme Court further refined what this as applied analysis means. And the important piece of it, and I think it goes to the question that Judge Fisher had raised earlier with Mr. McAvoy. The Supreme Court said, and I'm quoting here, an act found to be civil cannot be deemed punitive as applied to a single individual in violation of the double jeopardy and ex post facto clauses and provide cause for release. And the court went on to explain that allowing an individual by individual assessment of the effects of a law on each person would make the ex post facto law impossible, or ex post facto doctrine impossible to implement. So really, I think when we talk about as applied challenges in the ex post facto context, really it's a function of the intent effects test that the Supreme Court articulated in Doe and in Kennedy versus Martinez. And that effects test goes to the practical implementation of the law as opposed to the stated legislative purpose. And then when we look at that,
Kolb,
yes, Your Honor.
I'm grateful for that clarification. But what do we do with the fact that the Supreme Court did not address some of the circumstances that Mr. Arthur presents? Equally, WM did not address all that. Can we say that, well, we're not going to hear your claim because there are these two cases from the old days?
No, Your Honor, that is not what I would suggest, but I do think that the Supreme Court made very clear, and this court made very clear, that in order for an individual defendant to show that a statutory enactment is invalid under the Constitution as applied to him, there needs to be clear proof. And that type of clear proof we would submit does not really lend itself to this individual by individual granular assessment. Rather, we're looking at the statute as a whole. And when we look at the statute and its implementation as a whole, I think the Supreme Court said in Fleming versus Nestor that you need, quote, unmistakable evidence of punitive intent, unmistakable evidence of punitive intent with respect to the statute. And so, with respect to your question, Judge Fisher, we look at the statute of SORA, and we look about whether or not SORA, as a statute, standing alone, has these particular punitive effects. And we think that SORA does not, on its face or in its implementation, directly cause any of the harms that Mr. McAvoy's client has suffered, as unfortunate as they are. Rather, there are separate provisions, housing provisions, for example, some employment limitations. For example, he can't work in a school as a convicted sex offender. Those aren't related, those aren't SORA. Those are separate provisions, the legitimacy of which is really not before the court to begin with. But I would also note that this court addressed a similar type of argument in WM. In footnote 11 in WM, this court addressed the plaintiff's claim in that case that there was an amendment to the Sentencing Reform Act. And the amendment to the Sentencing Reform Act allowed judges in criminal cases to extend the period of supervised release for a defendant to be commensurate with the period of registration under SORA. The plaintiffs in WM said, therefore, that shows that SORA is punitive. And this court said, no, it doesn't. It doesn't show that SORA is punitive. That subsequently enacted provision in the sentencing regime is a wholly separate animal, and it doesn't reflect on the legislative intent at the time SORA was passed. And I think the same is true here. The fact that there might be subsequent enactments about housing and other things, that is something that has nothing to do directly with SORA.
So clarify for me what we mean when we apply the effects test in ex post facto litigation. Mr. Arthur's position is essentially, it really hurts me a lot more than it hurts other people. And that's punitive. And that is an effect. And so the Supreme Court has allowed other courts to look beyond the intent of the legislature and take into account the effects, whatever that means.
Well, Your Honor, I would think that looking at the Garner and Selling cases together, what we're looking at in terms of punitive effect is the statute as writ large, and it focuses on the class that it is intended to deal with, sex offenders. How does it affect sex offenders as a group? And we would submit that an individual showing, such as this defendant here, Mr. Arthur, would not be the clearest proof that there was a punitive effect in enacting SORA. Now, let's say there were many hundreds or millions of people who came forward and said, no, the practical effects are terrible, and the implementation of this statute, has had these effects, and they're directly traceable to the statute. That's a different question, but that's not what we have here. That's not what we have here. But I think the Supreme Court left the door open in the effects test analysis for that kind of a showing. But that's not the showing we have here.
Mr. Arthur has a plausible claim that he's been treated unfairly and it amounts to punishment. If that's not an ex post facto claim, then how does he seek relief?
Well, Your Honor, I think that the fact that he's being treated unfairly, assuming that that's true for sake of argument, that's a function of other statutes, such as the housing situation, such as an individual employer's decision not to hire him. And that unfairness isn't traceable to SORA. As the Supreme Court, I think, acknowledged, and this court acknowledged in WM, that's also fairly traceable to the fact that he has a felony conviction for second-degree rape. And a lot of the consequences that he is suffering, he would suffer whether or not SORA was enacted. And so when we're looking at whether or not SORA as a statute violates the Constitution, that showing cannot be made. And that's what the Supreme Court basically said in terms of housing and employment. In Doe, they said that, you know, you have to show that the harms that he is being exposed to, or a plaintiff in that case is being exposed to, were something different from, might have occurred if someone had done a background check or a reference check. And it's not. It's absolutely not. And that, I think, is the issue here.
There's a sense in your brief in which you half acknowledge that the trial court jumped too quickly. That when he said, these issues have been decided, I'm not going to conduct an individual examination of your circumstances. Are you now saying that, well, maybe the trial court's instincts were on the mark?
I think that's right. I think that as I drilled down on this question and found this additional case, I think maybe I was too quick to throw the trial judge under the bus, and I didn't mean to do that. But I do think that the trial court's instinct has foundation in the law. And, for sure, I think that the notion that each individual person can come to a court and challenge a statute based on his personal circumstances, I think the Supreme Court has said no. Now, if there were a class action suit and there were some other type of litigation, it might be a different story. And I guess the point I would say, and I don't want to totally step away from it, individual circumstances can be relevant to the practical effects, but they have to rise to the level of clear proof of punitive intent. And usually that is viewed by the statute writ large and how it's implemented against the class of people subject to the statute's provisions. And that kind of showing was not made here. It was not made here at all. The fact that Mr. Arthur has had some unfortunate circumstances, Mr. Arthur can vindicate some of those situations. In fact, he's doing that now in federal district court. He's been represented in federal district court. And he's challenged.
What do you say to Mr. Arthur's argument? I never got a chance to make my proof. You acknowledge that if you show that has this effect on a lot of people, then maybe that might be a viable claim. Judge wouldn't even listen to me.
Well, that wasn't the argument he was making below. I don't think it was anywhere near that. And I also think that even if hypothetically there were a group of people, let's say, who came forward and said, boy, we're having a hard time with housing, we're having a hard time with employment, I think this court and the Supreme Court acknowledged that general concern already and said, yes, that's unfortunate, but that's not traceable directly to SORA. That's traceable to the fact that you have a felony conviction for a sex offense. And that's not the kind of thing that would invalidate this legislative provision. And so I don't think, hypothetically, Judge Fisher, even if there were a whole group of people, that the traceability question to SORA, that's really the Achilles heel of the defendant's argument. And that analysis has not changed in terms of Smith versus Doe and In re WM. I think both of those courts acknowledge that general concern. So
is the Sixth Circuit, which governs my beloved home state of Ohio, simply out to lunch?
I don't know if I would say that, but I do think that case is arguably wrongly decided. And I think that it is an outlier situation. It's dealing with the particular provisions of Michigan law, and other federal circuits who have evaluated other federal and state laws have said that Snyder is limited to the unique harsh consequences that Michigan has decided to impose retroactively, in particular, limiting where people can live, work, and loiter. It can't be anywhere near 1,000 feet of a school, and also requiring immediate notification if you change your email, your phone, or any of your personal circumstances. The court found those were, in reality, very punitive, or at least envisioned a punitive intent. And so that's why Snyder was decided the way it was, and why many other circuits have said that their particular provisions don't run afoul of the ex post facto clause in the same way. Our provision here in DC also does not have that type of draconian limitation imposed on it through SORA. And so I don't think Snyder really gets appellant where he wants to go. I think for Michigan, that's a valid claim, but I don't think it is a valid claim, with all due respect, for the District of Columbia. And the only other thing I guess I should address is Mr. McAvoy has cited a number of cases and studies with respect to the efficacy of SORA and recidivism, and how this statute in reality has played out now that it's been on the books. Those are well taken for sure, but the place to address the policy concerns and the practical issues and whether this is a good idea, with all due respect, is not a 3-judge panel of the DC Court of Appeals. That's a question for the legislature. That's a question that could certainly be brought to the Congress that enacted SORNA, and it could be brought to the DC Council that enacted SORA pursuant to it. And that's what the Supreme Court has done in many other similar circumstances. For example, we cited the case in our brief, Ewing, which is the 3 strikes case, that the Supreme Court said, yeah, there are problems with 3 strikes laws, but guess what? We're not going to address them. That's a policy question better left to the legislature. That's exactly what we have here. It may well be that very smart people have good arguments to make about whether SORA is efficacious and whether it truly meets the goals that it espouses. But that's not a policy question, with all due respect, that this court should be deciding in the first instance.
Leaving aside for a moment your point about how we need to look at the effects on a class and not an individual, leaving that aside for a moment, is the fact that Mr. Arthur was charged in, I think it was 2011, with a sexual assault type crime, and I think he entered a plea to some lesser offenses or other offenses. Is that of any relevance, the charge against him, that it was a sexual assault charge, or is that something we just cannot fairly take into account, given that there's no conviction there?
Well, Judge, I would be, at least at this point, for purposes of our constitutional challenge, I wouldn't, or the constitutional analysis, I don't know how far I could take that. I think certainly it might argue in favor of the efficacy or need for SORA, that, you know, there is a possible concern, but he wasn't convicted. So how much weight do we put on that? I don't know. I don't think that, you know, we didn't rely on that in our brief, and I don't think the court needs to, or, you know, because it's such an arrest without a conviction is of such questionable value as an evidentiary matter. I'm not sure I would encourage the court to rely on it in this setting. I mean, if there were a hearing and, you know, everybody wants to really go through whether or not Mr. Arthur is a good candidate for some type of relief, I think that would be a fair point to raise, for sure. Your Honor, I guess the last thing I would say here is, in terms of the ex post facto analysis, what we're really looking at primarily is the statute. And we're looking at whether the statute, either as it's written and as it's implemented, punishes someone based on prior conduct that at the time it was committed was lawful. That's not what SORA does. What we have here is a statute that says if you're convicted of a sex offense, you must register. There's no question here, no dispute. Mr. Arthur had ample knowledge of his requirement to register. In fact, he had done so for a good period of time. He decided in 2015 he was sick of registering, apparently, and didn't do so from 2015 through November, I think, of 2016. And that is the basis for the criminal charge here. He failed to register when he was required to do so. That's a prospective requirement, a prospective punishment based on conduct that at the time he did not register was not legal because he had that obligation. That's not a violation of the ex post facto clause, I would dare say. That's something that is totally appropriate. There is an appropriate civil regime designed to protect the public. Part of that is to register if you're a sex offender. Mr. Arthur did not do that. And as a result, he, I think, has fairly been charged and convicted with a violation of that misdemeanor provision. And unless the court has further questions, we would respectfully ask the court to affirm the judgment below. Thank you.
Thank you, counsel. Mr. McAvoy, we'll give you a few minutes.
Thank you, Your Honors. The appellant would like to respond to two particular points. First, the point that SORA standing alone does not violate the ex post facto clause, and that the individual facts of a case cannot or should not be examined. The appellant would argue that how could the courts possibly measure this impact as applied if we do not measure that impact, if we do not examine those facts on individuals, though possibly that might apply collectively. The individual facts of a case are both inherently related to the weighing factors announced in Smith v. Doe and applied in WM. And additionally, they are the types of facts and factors that can and are typically reviewed by trial courts. The appellant argues that this is not only something that is within the realm of the courts, but rightly measured and rightly examined when we look at those weighing factors. The second point that I would like to respond to is that argument regarding the proper venue with respect to the policy concerns underlying SORA. And the argument has been raised that the legislature is the proper place to review that. And the appellant would say, yes, that too. The appellant's position would be that certainly that is something that SORA and the council looked at, but it's also a factor that is announced in the weighing factors with respect to does the SORA law have a rational connection to a non-punitive purpose? And that policy examination is once again listed as one of the factors that courts not only can look to, but should look to with respect to weighing whether this impact is unconstitutional as applied. And those are the points that Mr. Arthur would like to respond to. And I'd be happy to field any questions from your honors.
No, I think we're satisfied. Counsel, thank you both.
Thank you.
The case is submitted.
This court is adjourned.